with Hosanna lying on November 11th, was that a reason why you lied as well?
I feel like not saying nothing was like a mutual agreement without making it an agreement.
Okay.
Yeah,
Go ahead.
Yeah. That's it.
Yeah, tell me a little bit more about that. Like, what happened for you to believe that there was some kind of unstated mutual agreement?
I feel like just the way she would talk to me, like, just like little comments she would say here and there,
Okay.
when I would try to vent to her about the situation.
Okay. So let's go to October 3rd. When you leave Mr. Dickerson's house, after, using the metal file, did Hosanna wait for you in the car?
Yeah.
And we talked about you kind of being in the house. Were you in the house for a few minutes by yourself before going into the car with her?
Yeah.
Did you force her to drive you to a gas station?
No.
Was it her idea?
Yeah.
Did you ever tell her, no, let's go to the police right now?
No, I didn't.
And then when you went to the gas station, did she pay for the gas?
Yeah.
Did you ever think about just running away right then, taking off?
No.
Why not?
I don't know. I feel like at the moment, like, I just feel like, obviously somebody that you love, if you feel like they're in control of the situation, you're gonna like follow suit, and I know now that it was wrong, like, I should have not done all that.
Okay. Why do you say it's wrong now?
Because now I feel like I look back, obviously that was a lot of years ago, so I had a lot of time to like think about it and like, I don't want to say grow up, but like obviously mentally mature a little bit more,
When you say mentally mature, did you think that burning the house down on October 3rd was the right thing to do then?
I didn't know what to do.
Okay. Has that changed then now when you're saying I'm more mentally mature? It's shifted now. Is that fair to say?
Yeah.
Okay. So let's go back to, when you guys get to the house and you go inside. Did Hosanna go with you inside the house when you had the bottles?
No.
Okay. Did she wait for you outside?
Yeah.
And then afterwards, did you guys all stay together the next day?
Yeah.
And you guys continued to stay together afterwards?
Yeah.
Okay. Now, we talked a little bit on Friday about the backpack in the house. And just to kind of reorient everybody, who took the backpack out of the house?
Hosanna did.
Do you know what happened with that backpack?
The last time that I had seen it was in her sister's car, but she had all her stuff at her mom's house after that.
Okay. When was the last time you saw it?
It was in the car.
Yeah, do you remember like how long after this was from the 3rd?
I think it was like this the very next day or the day after that.
Okay. Did you ever get rid of it?
No, I didn't.
Did you ever see Hosanna use anything in the bag?
I don't even know what she put in there. I know that she had put alcohol bottles that she was drinking from. There was like 2 of them.
Do you remember what kind of bottles these were?
One was it was like a dark bottle, but the glass was like clear. I don't know exactly what it was. Okay. And then the other one was a Fireball.
Okay. When did you see her drinking out of these bottles?
The next day.
Okay. If I could just have one moment, please.
Sure.
Stacey, I just have a few more questions, okay?
Okay.
When you had gone back into the house and put the gas in the living room, did you feel like you had to do that in self-defense?
Not necessarily that part.
Okay. Did you feel that that night, using that file, that there was no other option for you?
Yeah.
Okay. Your Honor, nothing further on direct. Thank you.
All right, thank you. Any cross-examination, please? Go ahead.
Okay.
Do you have enough water, ma'am?
Thank you.
Do you understand why we're here?
Yes.
Objection relevance.
Or overrule the objection.
You do?
Yeah.
Do you understand that we're here because of Christopher Dickerson?
Yes.
If we could show Exhibit 1. That's him, right?
Objection,
Yeah.
sympathy.
All right, I'll overrule the objection.
Do you get that's why we're actually here, ma'am?
Yes.
Do you get that we're not here for your toxic DV relationship?
Objection, argumentative and relevance. Asked and answered.
I'll sustain as the argumentative. If you want to rephrase, Mr. Praler, go ahead.
Do you understand that we're here for your actions?
Objection, asked and answered.
I'll overrule the objection.
Yes.
Do you understand that we're here specifically for your actions of plunging that weapon in his neck
Yes.
5 times?
Yeah.
You understand that?
Yes. Sir.
Objection, argumentative.
Overrule.
And now you're saying that we're here and you want to explain a lot of things because of your social anxiety. Did I get that right?
Yeah.
Social anxiety. Can you explain what that means?
Just anxiety do you get when you're social?
Okay.
You're supposed to be
So you
social.
want to avoid social settings, right?
Yeah.
Where was your social anxiety on October 11th when you denied knowing him to a police officer?
I don't know.
I don't either.
Objection, is there a question?
There was a question, Mr. Praler. I'll sustain to your statement.
Do you know where
Ask
it's at?
questions, please.
It was there.
It was there.
Yes.
We just don't see it in the video. Fair? I mean, you just admitted to her that it looks on that video like you don't care, right?
Yeah.
Okay. And in that social anxiety situation, you denied knowing Christopher.
Yeah.
You denied seeing him,
Yeah.
being at his house,
Yes.
stabbing him.
They didn't ask me that.
Okay. Well, you were told of your charges, right?
Your Honor, we'd have asked to take down this exhibit at this point.
All right, I'll overrule the objection.
You were told of your charges, right? Of first-degree murder,
Yeah.
arson, burglary, and tampering with a deceased body. And you had social anxiety, right?
Yeah.
And you responded with, "Is there proof of that?"
Yeah.
to a police officer. Right?
Yeah.
Oh, and I'm sorry, Mr. Praler. Are you done referring to this?
Sure.
Okay, thank you.
Now, ma'am, you talked about your review of discovery, and you would agree with this notion that you were differently situated than any other witness in this case. Fair?
What do you mean?
Well, let me explain. Number one, you've heard everything, right?
Yeah.
You get to hear every witness.
Yeah.
You get to consult with your defense attorneys, right? Before your testimony, right? You did that?
Yes.
During your testimony, right?
Yeah.
Like multiple times during your testimony. I assume this weekend between your testimony? Right?
Yeah, she came and just asked me if I was okay.
Okay. So is that a yes?
Yes.
And you got to review all the supplements, every police report, right?
Yeah.
All the photos,
Yeah.
all the body-worn camera,
Yeah.
all the notes.
Yeah.
Did you review all the notes or did some catch you by surprise?
Objection, vague.
Give me just a second. Mr. Praley, can you rephrase that? I'm not 100% sure what you're asking.
Well, ma'am, there were a couple notes in opening statements, right?
Yeah.
Like a note to flush.
Yes.
Had you ever gone over that with counsel prior to that opening?
I mean, I just told him that I didn't write it, and that was that.
Okay, and that didn't answer my question, so I'm going to ask you to go back. Did you review that prior to me getting my screen up to come up for opening statement?
Yes.
You had reviewed it?
Yeah, discovery.
Okay. Do you remember that aspect of the delay in the opening because there was the argument that that note hadn't ever been discovered?
Objection, can we approach?
All right. Can the parties approach?
I mean, she's, I wouldn't say setting me up, but making herself seem like somebody she's not.
Okay, so why don't you tell me, why not take this golden opportunity and say, get your ass out here or you're going to end up like Chris?
Objection,
What's the objection?
argumentative and relevance.
All right, I'll overrule the objection.
Why not do that? That's a perfect opportunity, right? Instead of you just sitting outside, making it look like you're impatient,
I don't know.
you would agree with me that would make way more sense if she's trying to set you up, right?
I don't know what was going through her mind.
Well, she has free access to your phone,
Yeah.
and she doesn't write that?
I don't know what she was thinking.
Okay. All right, we can take that down. Ma'am, in the last day or so of your testimony, would you consider yourself a meek person? Or a mild person?
Like, what does that mean?
How would you describe yourself in terms of that? Are you very outspoken or are you quiet?
I would say now I'm kind of just neutral.
Just neutral, okay. Pretty passive, goes with the flow?
Yeah.
Yeah? You also testified you really just don't get offended by things, right? Just kind of go with everything? Do you recall saying that?
Yeah, I guess.
You're pretty accommodating in a relationship. Wasn't that your testimony? You don't care how long it takes. You don't care all this stuff. You don't care timing.
Yeah.
You also talked a lot about kind of your personality versus Hosanna's. Is that fair?
Yes.
And you had said on direct examination that you were much more masculine. Fair?
Yeah.
I believe you stated that it's pretty obvious that you're into girls.
I mean, yeah.
Okay? And is that based on how you talk?
I don't know. I feel like it's just like a vibe.
Just a vibe. But you give it off, right? Is that what your testimony was?
Yeah.
That it would be pretty apparent to people, right?
Yeah.
And you had also said that Hosanna was much more feminine, right?
Yes.
And she takes a long time to get ready and I guess gets more dolled up. Mm-hmm. You had said that she was the one that would get guys to buy the drinks,
Yeah.
right? She would flirt with them, right?
Yes.
And you're the passive person with social anxiety that really doesn't like having conversations with other people.
I don't.
Okay. But then you're essentially saying, as obvious as that was, on October 3rd, Chris just couldn't pick up on anything that you're putting down.
I mean, some guys just don't care.
Okay. But you're
Don't realize
saying,
it.
what was that, ma'am? I'm sorry.
Or don't realize it.
Don't realize it. Okay. So you're saying essentially that Chris was just into you and Hosanna is not getting any attention, right?
Well, no, I didn't say that.
Well, I'm asking.
No.
Who's getting more attention?
I think it was evenly distributed.
Evenly distributed, okay. But he's touching, according to you on your direct examination, he's touching your butt, not hers,
Yeah.
right? I mean, he's into you, and you keep deflecting the situation to Hosanna like, you might want to talk to her, right?
Yeah.
That's what you're telling this jury.
Objection, misstating the testimony.
All right, I'll overrule the objection.
And that's throughout this night that apparently Mr. Dickerson is just all about you instead of the more girly girl, feminine woman of Hosanna, right?
Yeah.
That's what you're telling this jury.
Yeah. Well, I was reflecting the conversation to her at the beginning. After that, I kind of just stopped talking in general.
The conversation's in the beginning.
Yeah. That's what I said.
With him?
Yeah.
And so he's just like all about you.
I wouldn't necessarily say that, but yeah, I wasn't used to that kind of conversation. I don't really.
Can you finish your thought?
Yeah, I don't really socialize like that, so.
Okay, and you don't think that would be obvious?
But I don't socialize.
Yeah, to him.
Objection, speculation.
I'll sustain the objection. Mr. Praley, if you want to rephrase, go ahead.
Is it your testimony that Chris just couldn't pick up on any of these things that you're saying that's the way you were that night?
Yes.
Okay. Now, ma'am, I'm going to switch gears to intoxication a little bit, okay?
Okay.
You admitted, no doubt, you're drinking that night and you're drinking a lot. Fair?
Yeah.
In general, do you think people remember more details when they're sober or when they're intoxicated?
Objection 702.
I'll allow the witness to answer if she can answer.
I'm not sure.
You really are not sure if people remember more details when they're sober or intoxicated?
Objection argumentative. She already answered the question.
I'll sustain the objection. She answered the question.
Would you say people are more reasonable when they are sober or intoxicated?
Objection 702.
I'll allow her to answer if she knows.
Can you repeat the question?
Yeah. Do you think people are more reasonable when they are sober or intoxicated?
I'm not sure. It depends on which aspect.
Well, explain that for me.
Like, I don't know. Some people, when they're sober, a lot of people don't even show emotion, but when they go and get drunk, they cry and they express their feelings. Like, so it just kind of like, it's different every situation. Or
Okay. So you don't think people in general are more reasonable?
I feel like everybody's different, so you
Okay.
can never tell.
Okay. You had stated that you were drinking throughout that night.
Yes.
From the time you get with Hosanna, you're drinking in the car,
Yeah.
right? You're drinking at the bar.
Yeah.
You're working very hard to actually get into that bar, fair, right? You're going through separate entrances.
Yeah.
I mean, you got to the point that you kept looking for an after party, right? To
Yeah.
keep drinking,
Yeah, she wanted to go.
but you didn't.
I really didn't.
Okay.
If it happened, if it didn't, I would.
But at that point, you keep drinking, right?
Yeah.
And you had said you get to the point where you're kind of spinning.
I didn't say that. I said threw up.
You're trying to say that at no point during your testimony last week
I said I wouldn't really say spinning.
at all? At any point?
Objection argumentative. She's already answered this.
I'll allow the witness to clarify.
I said I wouldn't necessarily say spinning.
Okay. And at one point, you get so intoxicated that you were throwing up.
Yeah.
Okay. You had talked about this progression of pouring these shots at Chris's house, right?
Yeah.
That he started first. Then it goes to Hosanna.
Well, we all kind of just took turns.
Okay. Let me finish, okay? First, it started with Chris.
Yeah.
He was pouring shots. Then it started with Hosanna. And then at the end, you are pouring the shots, right?
Yeah.
You're pouring them last, right?
Yeah.
You are the last one to keep pouring vodka, Ciroc, as you said, for Chris.
I wasn't the last one, but yeah.
Okay. And everybody agrees you had just met Chris.
Yeah.
You agree there's this trip to pick up Dolores.
Yeah.
And you agree that his phone's working at that point, right?
Yeah.
Because he's getting phone calls,
He's on it, yes.
right? And then ultimately, really where this comes back, it diverges once you get back to the place, right?
Yeah.
And ultimately, in the end, and we'll talk in more detail, you would agree that no one stabbed Mr. Dickerson other than you,
Yes.
right? I mean, Hosanna didn't,
No, I said that.
okay? And you would agree that when his phone's going all these places after the fact, he's not alive, right?
No.
Okay? And he didn't tell you in his last dying breaths, hey, take this ring, take this phone, right? He never gave that to you. And then you agree that Hosanna goes out and gets into the car before you, right?
Yeah.
You know all those details. Fair?
Yeah.
And you agree with all that. Fair? You agree that you come out minutes later and actually get into the car.
Yeah.
You agree that you drove to this gas station.
I didn't drive, but I sat passenger seat, yeah.
Thank you for that clarification. You guys go to that gas station. Gas is purchased. You return to Mr. Dickerson's house. He was dead at that point, right?
Yeah.
You agree that you're the only person who actually goes in.
Yeah.
You would agree because he's dead, he can't give you permission to go in.
And Ms. Rodriguez, you have to answer out loud.
Yeah.
You agree that you go inside and you start the place on fire.
Yeah.
You agree that when we look at those photos of Chris, that's because you burnt him,
Yeah.
right? And then you agree that you go back to your brother's house and you switch to get into the the Tahoe, right?
Yeah.
Okay? All those things you agree with.
Yes.
But we really disagree about this event of what happens in that struggle, right?
Objection, counsel's testifying.
I'll allow the question. Ms. Rodriguez, can you repeat that answer? It's really hard to hear you sometimes.
Yeah.
Okay. Man, when we get to that self-defense, is that's what you're claiming, right?
Yes.
You're saying to this jury, Chris deserved to die.
Objection, can we approach?
Sure.
Fair to say you're telling this jury that based on Chris's actions, you had to kill him.
Yes.
And no one else stabbed him. We've established that, right?
Yeah.
And when we go through that progression that you talked about last week, you are saying that at some point, Hosanna just brings this weapon out
Yes.
and just gives it to Chris?
I don't know who she was giving it to.
Well, she didn't hand it to you, is what your testimony was last week, right?
We're right in front of each other. I said she could have been drunk. She was drunk. I don't know.
Like, that's a pretty big drunk mistake of like, hey, I'm gonna go over here. I see that you're in a struggle, and I'm gonna then take this weapon, and I'm just gonna come over and hand it to the wrong person.
Objection, counsel's testifying.
I'll overrule the objection.
Is that what we're saying?
Yeah, well, I can't speak for her. I don't know what she was thinking.
But you're speaking that that's what she did, right?
Yeah.
Does that make any sense to you why she would, if you're in trouble, your life is in fear,
Yes.
that she would bring it to a person that she hadn't met versus her lover?
She was also drunk, so I don't know what she was thinking.
Okay.
I can't speak for her.
And so we're just going to stick with the she was drunk.
I assume.
Okay. But you agree, in terms of her role, all Hosanna did, in terms of that weapon, was go get it and bring it. Now, you say she gave it to Chris. She says she gave it to you, right? But you agree, she just transported the weapon.
Yeah.
Okay. And then you had said at some point that you used a Budweiser bottle before you had stabbed him, right?
Yeah.
And I believe your testimony last week was that essentially those Budweiser bottles are out and around. Fair?
Yeah.
And you were drinking some of those, Chris was drinking some of those?
Pretty sure, yeah.
Okay. And ultimately, at some point, you picked that bottle up and you threw it at him.
I didn't throw it at him. It went over him.
It went over him. And I assume it broke, right?
I don't believe that it broke.
So we just throw a bottle and it didn't break anywhere.
No, it hit cushion, so I doubt that it broke.
Okay, so now you're saying it hit a cushion.
Well, I
Do
said
you
it hit
recall
the
saying that last week?
Yeah, I recall saying that it hit the couch.
Okay, so there's just this throwing, you only use a bottle one time and now it hits the couch.
Yeah.
Okay, that's your testimony.
Yes.
And does that bottle ever get used again?
No.
Where does it go?
I don't know where it went.
You have no clue?
The couch, but
But there were multiple bottles around, right?
yeah.
You agree that after you light the house on fire, those could have burst, right?
Objection.
I don't know
cause
how
for
that works.
speculation.
I'll accept that. I'll let the witnesses answer, Stan.
You don't know, ma'am?
I don't know how that works.
Okay. And then it's your testimony, based on last week, that Hosanna is essentially in the room with you the entire time period of this altercation. Fair?
I'm pretty sure, but I mean, I wasn't really looking at her. I don't know where she was.
Well, you weren't really looking at her, right?
Yeah, obviously I was focused on the situation that was happening.
Yeah, but you're also not looking at him when you're stabbing him, right? Remember your testimony last week that you're
Objection,
just...
can the witness answer?
All right, Mr. Fraley, let her answer the last one before you move.
Okay.
Can you repeat it?
Yeah, you're not looking at her, right?
Yeah.
You're not looking at him, right?
Yeah.
What are you looking at?
I don't know.
Me neither.
Objection, counsel is testifying, asked to
I'll
strike.
sustain the objection and strike counsel's response.
So you know all these details, but you don't know what you're looking at in terms of who else is in the room or where Chris is positioned or where Hosanna's at?
Objection asked and answered.
I'll overrule the objection.
When I wasn't looking, it was like obviously I was looking at him most of the time, except for those few seconds that happened.
Okay, so you're looking at him pretty much the whole time except when you're plugging away into his neck 5 separate times in a very close area.
I didn't know that I did that at the moment.
But you did, right?
I did.
Okay. And so what I don't understand on this in terms of this progression where you talk about this happens in the kitchen, he's hovering over you, you push him into the fridge, you're trying to leave, and then he pulls Hosanna back, right?
Objection, counsel is testifying. We'd ask to rephrase without what he doesn't understand.
I'll overrule the objection.
Is that yes?
Yes.
Why would Hosanna not say, we are trying to leave?
Objection, cause for speculation.
I'll sustain the objection.
I don't know.
Why would she not say she got pulled back?
Cause for
I
speculation.
will sustain the objection, Mr. Fraley.
You're saying you saw Hosanna get pulled back,
Yes.
but you're at the door, right?
Yeah.
You're the first one. You're the fast one,
Objection, counsel is testifying.
Overrule.
right?
Yeah, well, I walked out, grabbed her hand and pulled her. Yeah.
Okay, so you're at the door before her.
Yeah.
So you're looking forward at this point.
Yeah.
She's behind you.
Yes.
How do you see behind you that Mr. Dickerson pulls Hosanna?
I turned around because I couldn't get the door open.
Okay, so you just can't get the door, and at that time is when you see him pull her back. And what does he actually do to her?
Nothing. I told her, I pushed her back. I was like, leave her alone.
Okay, so at that point, you're at the door, you can't get the door open, you're trying to leave, and he's charging towards the door?
Or at us. I'm not really sure at what. Well, he grabbed her, so.
Okay, and you can't get that door open. You had no problem the rest of the night getting the door open when you came back, forth, right?
Yeah.
But in that moment, you couldn't get out. He pulls your girlfriend back, and then you turn around and you push him, right?
I pushed her back.
You pushed her back?
From the door or before that?
I'm still talking about this door situation,
Yeah.
right? You can't get the door open. Hosanna's behind you. You said you turned back, and that's when you see Chris pull Hosanna.
Yeah.
And then do you push him?
No, I scooted her back.
You scoot her away,
Yeah.
but he's pulling her.
Yeah. And obviously after that, the attention reflected on me.
Okay, because she's being pulled back and you're pulling her out of the way?
Objection asked and answered.
Overruled.
Is that what I'm hearing?
Yeah, I kind of just separated the situation.
You separate it. Okay, and then do you react to Chris?
I told him to leave her alone, yeah.
Okay. And did he touch her again?
Oh, he got in my face after that and
He
pushed
got
me.
in your face.
Yeah.
Okay. And at what point then do you push him?
This was before when I had to push him, it was in the kitchen.
You only pushed him in the kitchen.
Yeah.
Okay, so now after he pulls Hosanna and you then get her out of the way, he directs his attention at you,
Yes.
right? And then,
I said yes.
yes? And he doesn't have anything in his hands at this point, right?
No.
Right? We're not to that point in the story.
Your Honor, could we approach, please?
Sure.
And so again, he's not holding this, is he?
No.
Okay. And so then tell the jury what happens after. After you pull Hosanna away and he comes towards you.
He pushed me onto the couch.
He pushed you to the couch. Ma'am, how much do you weigh?
I'm not sure. At that moment, I'm not really sure. Like 250?
Okay. And is it your testimony that he's super strong?
I believe that he was. And I was also drunk, so it was easier to obviously catch me off balance like that.
Okay. So it's because at that point you're very drunk and your balance isn't
He's
good.
also a man, so
Okay. And you would agree that you outweigh him, right?
yes.
Objection calls for speculation.
Overruled.
And you're just saying because he's a man, he can push you all the way through the couch, right?
Yeah.
That's your testimony.
Yes, it is.
Objection asked and answered.
I'll sustain the objection.
Okay. And then ultimately, at that point, he's intoxicated too, right?
Yeah, I'm pretty sure.
So his coordination, his balance is off, right?
Yeah.
I mean, that applies equally to people?
Objection 702.
I mean, yeah, I don't know how often,
I'll overrule the objection.
how much he was drinking.
Okay.
And Ms. Rodriguez,
yeah.
can you repeat that since we were talking at the same time?
Yeah, I wasn't sure how much he was drinking, so I don't know how drunk he was.
Okay. And then ultimately you go, this is where we now get to the couch, right?
Yeah.
And there's this whole dynamic struggle. Is that fair to say that a lot of people are moving, turning, sliding,
Yes.
right? A lot of movement.
Yeah.
And you're saying he's holding you at one point with one hand, right?
Yeah.
He doesn't have anything in his hand at that point, right?
No.
He doesn't have a bottle in his hand.
No.
He doesn't have the weapon in his hand.
No.
And he's just holding you.
Yes.
And you guys are both on the couch at this point?
Yeah.
And then at that point, you start discussing that you're kicking him, you're punching him, you're trying to get away.
I wasn't punching him.
You never punched him? No?
No.
Okay. Okay. And then at that point, just randomly, this weapon comes miraculously from Hosanna to you.
To one of us, I'm not sure who.
You don't know if it was Chris, or you don't know if it was to you?
I don't know.
Okay, so you don't know who had the weapon first?
No, I don't know who she brought it to.
Okay. Who did it go to first?
He
Who
grabbed
touched it first?
He did.
Okay. So then at that point, Hosanna just brings it to him.
Objection asked and answered.
Overruled.
He didn't have it in his pocket, right?
Right.
And then ultimately, you talk about this struggle for this weapon where you are able to overpower him and get it out of his hands, right?
Yeah.
And this is a very dynamic event.
Yeah.
I mean, you're fighting him off, right?
Yeah.
He's not on top of you. He never stabs you with it.
No.
You're squirming.
Yeah.
He's squirming.
Yeah.
You're kicking him.
Yeah.
He's kicking you.
Yeah.
You're both moving around.
Yeah.
You're trying for this beer bottle,
Yeah.
right? And you throw it with an inside hand motion. You recall doing that last week?
Yeah.
And that's how you did it?
Yes.
And now it just hit the couch and just stayed there, right?
Yeah.
And then ultimately you roll to the floor.
Yeah.
Are you on top or is he on top?
We're side to side at the beginning.
Side to side, so you're now on the floor.
Yeah.
You described it as a semi-roll.
Yeah.
And ultimately you are able to get this weapon out of his hands.
Yeah, it was two of my hands on one of his.
Okay, so you could overpower him.
Yeah.
And you put your weight on him, right?
No.
Not at all?
I was over him, but I wasn't laying on him.
Okay, so how do you just pry it out?
I just went over him.
So you're just stronger in that moment.
I mean, I guess.
And ultimately, at that point, you're not looking at him. Once you get that in your hand, right? Once you get this, 143, once you get this in your hand, you're not looking at him.
No. Well, he kept grabbing me by my face, so I looked away.
Say that again, ma'am.
He kept grabbing me by my face, and he looked away. I would look away.
He kept grabbing your face?
Yeah.
Do you recall testifying to that last week?
I'm pretty positive, yeah.
Okay, so he's like grabbing your face.
Something like that, yeah.
Okay, not strangling you, right?
No, it's in my face.
Say that again, I'm sorry, ma'am.
I said, no, it's in my face.
What's in your face?
His hand.
Okay, so his hand is in your face.
Yeah, so I just
But
turned.
you just turned. You could do that, right? You're able to break your face free, right?
Yeah.
Okay. And again, you have this in your hand at this point.
Yeah.
And I recall last week that you were essentially saying you have this weapon that you had seen, right?
Yeah.
And you agree there was a handle on it at some point,
Yes.
and that you have it in your right hand,
Yeah.
and you're right-handed.
Yeah.
And if I recall correctly, you're saying that you're essentially going backwards,
Yeah.
right? Just like a tricep exercise, kind of, right?
Yes.
And you don't know where that's going because you're not looking at him.
No.
It's your testimony that during any of those tricep exercises with that weapon, that you're not looking at him, right?
Yeah.
And you start stabbing him. To be clear, you're trying to stab him, right?
Yeah.
That's not an accident.
No.
You're intentionally doing it,
Objection asked and answered.
Overruled.
right?
Right.
You're deliberately putting your hand back towards his face or wherever he's at.
Yes.
And if I understand your testimony last week, you're saying that he's still continuing to grab you during this time when you're doing these tricep exercises.
Yes.
And So he's grabbing you. Was that the demonstration that you and Ms. Trujillo had?
Yeah.
And you're kicking him,
Yes.
and he's kicking you, apparently, right? And so we're moving all these ways. Fair?
Yeah.
I mean, he's not just laying there, is what your testimony is.
Yes.
Okay? Do you find it astonishing that each of those 5 stab wounds are in such a small area when with all that movement?
Objection relevance?
I'll overrule the objection.
Objection, I think counsel might need to rephrase. We can approach if
Sure.
necessary.
You agree with me on all that movement, right?
Yes.
Is it surprising or shocking to you the number of times you stabbed him?
Yeah.
Is it shocking and surprising to you with all that movement how close all of those stab wounds are in the same area on his body?
I mean, it could happen.
Say that again, ma'am?
I said, I mean, it could happen.
It could happen?
Well, yeah, it happened here with that.
I mean, with all that movement, aren't you equally surprised that you didn't hit him one time in the arm?
Objection relevance?
Overruled.
I guess.
Or the chest?
Yeah.
Sorry, ma'am, you got to speak up.
I said, yeah. Yes.
That surprises you?
I mean, if it did or it didn't, I feel like it's everything. The whole thing is like, I really don't know what you're asking.
Okay, what I'm asking, have you ever played darts, ma'am?
No.
No? You know what a dartboard is, right? Generally?
Yeah.
You've seen them at some bars? Like
Yeah.
it's the
I've seen it.
circle, has different numbers?
Your Honor, could we rephrase?
I'll allow the witness to answer if she knows. I think she was about to answer.
You can answer, ma'am.
I've seen it like on the phone apps and stuff.
Okay. You understand there's like different numbers and then there's a bullseye there, right?
Yeah.
It would be pretty hard for somebody to not look at a dartboard and hit the bullseye 5 times, right?
Yeah.
What do you think the odds of that are?
I'm not sure.
Pretty low?
Objection asked and answered.
Overruled.
I'm not sure.
What do you think the odds are that if there's all this movement that you hit him 5 times in the same spot?
I'm not sure.
You're not sure at all?
No.
And then ultimately you're saying at no point is your hand coming forward towards him, right?
What?
Is it your testimony based on last week that at no point when you're holding that weapon that your hand is coming forward rather than going back?
Yeah.
Yes? You're agreeing with me that you're not super coordinated that night because of how intoxicated you were, right?
Yes.
And you're not saying you're the strongest person that any of us have met, right?
Yeah.
If we could show 170. Do you see that, ma'am?
Yeah.
Does that look like that just went in a little bit?
No.
Looks pretty far, right?
Objection asked and answered.
Overruled.
Yes.
And you would agree with me that that corresponds to the last time you hit him with that weapon,
Yeah.
right? You plunged that in so far. If we could show 156. You plunge it all the way through that, ma'am. Right?
Yeah.
Go ahead and look. You agree with that scale that that's a really far way.
And Mr. Praley, when there's objection, give me a chance to hear it. And I'm sorry, Ms. Trejo, I only heard the objection. I didn't hear what it was.
I didn't think there was a question. It was go ahead and look. Is he asking her a question?
Yeah,
He can direct her to the exhibit, so I'll overrule the objection.
you see in 156, that's his neck, right?
Yeah.
You put that object in his neck,
Yeah.
and you see that scale at the bottom, and you did all of that, right?
Yeah.
Okay. And you would agree with me, that's not a little distance.
No.
You would agree with me that based on that and 170, that the blunt side is going into his neck.
Yeah.
And you would agree with me that in order to put the blunt side that far into his neck, that would require a lot of force.
Well, yeah, the last time that it happened, I felt what happened. I felt onto him what happened.
Okay, so the last time you had a lot of momentum and a lot of force?
Yeah, I didn't realize I had did it before.
Say that again, ma'am?
I didn't realize that he had got stabbed when the last time happened.
Okay, well, I guess we can show, say, 160. See, that's pointing out the hole there, right?
Yeah.
And then 161's right next to it, if we can show that. You didn't realize that you're missing, that you're hitting at the same point, like centimeters away?
No, I didn't realize that.
Okay, and then we get into 162. And Dr. Burson talks about each of these stab wounds right in there. You see this, man?
Yeah.
And all of those were only caused by you.
Yeah.
And all of those, you would agree, are very close together.
Yes.
And it's your testimony today that you just didn't know you hit him
Yes.
because you're not looking at him.
Yeah.
We can take that down. And is it your testimony today that you didn't realize that just because you're not looking at him?
Yeah.
Did you notice any blood?
In the heat of the moment, I honestly didn't.
164. Ma'am, on 164, there was a discussion of the carotid artery. You see that?
Yeah.
You do?
Yeah. It's over there.
Okay. You understand that Dr. Burson testified about how much of a bloodletting process that would be.
Yeah.
You also heard your co-defendant discuss all that blood,
Yeah.
and you just didn't notice the blood?
In the heat of the moment before the last time, I didn't.
Okay.
It wasn't until after that.
We can take that down. And then ultimately, we get done with all that. You're saying heat of the moment, cools down. You see him with that weapon plunged into his neck, the handle broken off, right?
Yeah.
You got the handle.
Yeah.
You keep the handle.
No, I dropped it on the floor.
You just dropped it on the floor.
Yes.
Did it get burnt in the fire?
I assume, yeah.
Okay. And so, in that moment, afterwards, it's your testimony then that as he's dying there, right,
Yeah.
that you and Miss Varela just start going through his stuff.
She did.
She did.
Yes.
You had no part of that.
No.
Okay. But she had no part of the murder, right?
No.
She didn't stab him once.
No.
And so now you're saying as he's laying there choking on his own blood, she just decides to go through his stuff, but you do nothing.
Yeah.
That's what you're saying?
Objection asked and answered.
I'll overrule the objection.
Yes.
Is that a yes?
Yes.
So she's going through his bedroom.
Well, initially she had said she was looking for cameras.
She's looking for cameras. Well, cameras would help you though, right?
I don't know.
Well, you're explaining to this jury that some person put you in a position where you had to stab him 5 times to save your own life, right?
Yeah.
Wouldn't a camera be pretty helpful for that if this is true?
I don't know. That's a question for her. That's just what she said.
Okay. Well, you would agree that those cameras would help you, right?
Yeah.
They just didn't exist, is what you're saying.
I don't know.
And so after you look for cameras, that you don't see any, then she starts going through all the stuff,
Yeah.
right? You didn't do any of that,
No.
but you knew she was.
Yeah.
Objection asked and answered.
Overrule.
And you're putting at least gloves on at some point, right? At least one.
Yeah.
That was your testimony last week. You don't cover up the bloody hand, your right hand,
Yeah.
but you throw it on your left hand.
Yeah.
Why would you throw on gloves if you're not going through anything?
She told me to.
Okay, so at this point, you're just listening to her,
Yes.
and she's ordering you around,
Yeah.
even though she had no part of the homicide.
Yeah.
And then ultimately, she's ordering you around, and then she goes out to the car without you. Right?
Yeah.
Why wouldn't she order you out to the car?
I don't know. Obviously, that's not a situation that you know?
You would agree she took stuff, though, right?
Yes.
And you knew of that stuff,
Some of it.
okay? Well, you knew his phone, right? You'd agree with me on his phone that that was taken.
But yeah.
You're not disputing that.
No.
You're just saying you don't see this ring,
I don't.
okay? And then she, meaning Hosanna, tells you that she's going out to the car, right?
Yeah, she said, let's go.
Okay, so she tells you to go, and you don't listen at that point.
And I wasn't really listening the whole time.
Say that again, ma'am?
So I really wasn't listening like the whole time.
You really weren't listening to her at any point?
No, she was telling me to help her and I didn't.
Okay, so you're not listening to her at all when she says, let's get out of this guy's house that you just stabbed 5 times, right?
I ended up doing it, yeah.
So that's not a social anxiety situation for you to talk back to your lover who's ordering you to commit a burglary in that moment, right? That's not a social anxiety situation? Because you stand up to her, right? You say, I'm not robbing that guy.
Objection, counsel is testifying. There are multiple questions without an
All
answer.
right, Mr. Praley, give her a chance to answer.
You can answer, ma'am.
Question?
Yeah, you're standing up to her in that moment, right?
I mean, like, I wouldn't was just standing there.
Say that again.
So I kind of was just standing there.
Okay, ignoring her then,
I wasn't ignoring her. I wasn't really catching what she was saying.
because you couldn't hear?
At that moment, I felt like a lot of emotions
Okay,
got in the way of,
like guilt,
I would say, like more shock and panic at that moment.
shock and panic? Okay. You had discussed with counsel this whole like fight, flight, or freeze, and you hadn't heard those before last week's testimony, right?
Yeah.
And you had agreed that you were more of like the freeze type.
Yeah.
But you would agree with what you just described in the actual murder where you stabbed him 5 times with what's in front of you. That's a fight response, right?
Objection, invading the province of the jury in regard to murder.
Over.
Yeah.
So in the moment before, you're in a fight mode,
Yeah.
and you actually killed him. And then afterwards, you're getting bossed around, and you just, I can't take this. And you just shut down and stand in there for a couple minutes by yourself and your thoughts,
Yeah.
while Chris is gargling on his own blood.
Yeah.
Okay. And in that moment, you didn't listen to her. You'd agree with that, right?
Yeah.
And you stay in there as she goes outside.
Yeah.
And then ultimately, you go out to the car,
Yeah.
not in a fast way, right? Earlier in the night, you talked about this whole that you're running to the door, trying to get out. You can't open the door, right? You ran there.
Didn't run.
You didn't run?
I walked fast.
Walked fast?
Yeah,
You would
kinda
agree
like
with me
rushed.
that... Go ahead, man.
I finished it.
What's that?
I said I just kind of rushed.
Rushed.
There's not enough. Yeah.
A fast walk.
Yeah.
So you had a fast walk to the door to try and get out before anything happened, but you don't have a fast walk when you go to the car after you've murdered them, right?
No.
That's a slow walk. Right?
Yeah.
Does that make sense to you?
I don't know.
I don't know either.
Objection, counsel is testifying.
I will sustain the objection, strike counsel's response.
And so then, right after, you get in the car. Yes?
Yeah.
And Hosanna is driving.
Yeah.
And it's your testimony at that point. The woman who had no part of the homicide,
Yeah.
the woman who simply brought the weapon to Chris, according to you,
Yeah.
you according to her, right?
Yes.
She then says, we got to burn this place down
Yeah.
and kill the dog.
Yes.
Okay. And so are you saying that she then drives to the gas station?
Yes.
Is there any discussion happening?
No.
And then you go to the gas station. Do you actually pump the gas?
Like in the bottles?
You get a bottle,
Yeah.
and ultimately, do you fill it with gas?
Yes.
And then you go back to his residence,
Yes.
and you're saying it's Hosanna's idea to do this,
Yes.
even though she doesn't go in,
Yes.
and you're being ordered at that point to go in and burn the place down
Yeah.
and kill a dog.
Yeah.
And you just take that order,
Yeah.
okay? And so you go do that. So when you walk in, right, you know he's dead.
Yes.
You know you're not authorized to be there, right?
Yeah.
You go in the front door.
Yes.
The dog's in there.
Yeah.
Is Juna by Chris's body?
I'm not sure.
Do you think that dog would be protective of its owner that is bleeding on?
Objection, calls for speculation.
Oh.
Relevance.
I'll sustain the objection.
So you just don't know where this dog is,
Objection asked and answered.
Overruled.
right?
Yeah, I said no.
But the dog's inside,
Yeah.
and ultimately, you don't kill the dog.
No.
You let the dog out
In the back.
into the back. If you're under so much control from her, why not kill the dog?
I don't know.
I mean, that's what you were ordered to do, right?
Yeah.
At that point, you're following orders,
Yeah.
but you didn't follow that one.
No.
So your social anxiety didn't cripple you then.
Yeah, I wasn't talking to nobody.
What's that?
Social anxiety is like when you speak.
Okay. Well, it's also how you act, right?
Yeah.
And in that situation, you're ordered by Hosanna to go in, burn a place down, and kill a dog. And you say, hey, I'll burn this place down, but I'm not killing that dog.
Yeah.
Okay? That's your action. That's your choice, right?
Yeah.
And then you actually go in, and it's your testimony you brought the gas,
Yes.
right? And did you put the gas out?
Like pour it out or?
Yeah.
Yeah.
Okay. And ultimately, you get a lighter that you would have, right? Because you smoke.
Yeah.
And you light a piece of paper on fire. Was your testimony last week, right?
Yes.
And then ultimately, you drop that to the floor and start watching it burn,
Watch the paper burn.
right? And you knew what was going to happen with that paper.
Yeah.
You knew what that was going to do to that area.
Yeah.
You knew what that was going to do to this body.
Yeah.
You knew in this case that Mr. Dickerson had to be identified by dental records.
Yeah.
You did that.
Yeah.
And then you calmly walked back out to the car. Right?
Yeah.
Not your rushed walk the first time when he was trying to chase you in Hosanna.
Objection asked and answered.
Overruled.
Yes?
Yes.
And then you drive away. Right?
Yeah.
And ultimately, you switch cars
Yeah.
and you start laying low.
I mean, I wouldn't say laying low.
Okay? And this happens for a period of time. You had talked about that you don't want to go to the police because you don't trust the police, right?
Yes.
And ultimately, in terms of these conversations afterwards, you're saying there's just kind of this agreement that you wouldn't go to the police, right?
Yeah.
Because that's not what she wanted. Isn't that what, you didn't want that either though, right? Right?
Yeah.
And you stated on direct that you understand that it looks like you wanted to get away with it,
Yeah.
right? That's pretty obvious to you, isn't it? Now looking back?
Yeah.
And then there are these conversations after, and you say, it's not what she would want. Guess what I fail to understand is, why wouldn't that have helped you?
Can you repeat the question?
Yeah, why wouldn't it have helped you for you guys to go to the police?
I don't know.
It would have, right?
Yeah, I think we're just scared at the moment.
Okay. But she didn't kill anybody. You did.
Yeah.
So it benefits you to come to the police and say, I did it out of self-defense, right?
Yeah.
And it benefits her because she's with you and gives that weapon.
Yeah.
So why in the world wouldn't it help her as well?
I don't know.
It would, right?
Yeah.
And she's not the one doing it. It helps her and it helps you. That's a 2-for-1, right?
Yeah.
Okay. Now, ma'am, during this time period, you talked about these jail letters, and there's a couple that I want to be very clear. You're saying that you did not write. Is that fair?
Yes.
If I can approach, and I'll take this away, ma'am. Showing her what's been marked as 220. Ma'am, you recognize 220?
Yeah.
But again, that's not one you wrote, is your testimony.
It's not.
Nothing I say is going to change that, fair?
Yeah.
Okay. I'm going to approach with what's been marked as 238. It's discovery page S3638.
What's the base page?
3638.
Correct.
Sorry, wait.
I'm going to hand you what's been marked as People's Exhibit 238, ma'am. I want to ask you and kind of go page by page on it, okay?
Okay.
You would agree on the cover, on the outside, that would be like an envelope, right?
Yeah.
And you would agree that it says that it's from Stacy Rodriguez. That's you.
Yeah.
You would agree that it's saying that you are at the Weld County Jail.
Yes.
And you would agree that it's saying 2110 O Street.
Yeah.
That's the jail. Fair?
Yes.
And then that's addressed to Janira Rodriguez
Yeah.
in Evans. And there's a stamp on it.
Yes.
And you know Janira, right?
Yeah.
And she's a friend of yours?
Yeah.
And then on page 2, you can just look at that, ma'am. On the top corner, you number those. You see the 1 up at the top? That's technically on page 2 of the exhibit.
Yeah.
Okay? And fair to say there's nothing like domestic violence related in this letter?
I don't believe so.
Okay. You include a drawing in that? You can look through it?
Oh, yeah.
Okay. You drew that?
No.
Okay. And the final page, you see that it says La Amor de Mi Vida and then Stacy Rodriguez?
Yeah. Hold on. Yeah.
You would agree with me as to all those foundational aspects?
Objection, we'd ask to rephrase.
I'll allow the witness to answer the question if she
Should we do
understands.
that?
Yeah, you agree with all those things that I've just gone over, that that's from you?
Yeah.
Do you need more time to look at that letter? Okay. Fair to say, in this one, you wrote that letter? Is
Yeah.
that a yes, ma'am?
Yeah.
Okay. Your Honor, at this time, I move for the admission of 238.
Any objection to 238?
Yes, can we approach?
Sure. And can you bring that up, please?
Sure. Okay. Ma'am, you have 238 in front of you, right?
Yeah.
As well as 220 now.
Yes.
And to be clear, you're admitting that you wrote 238 and denying that you wrote 220, the big one,
Yeah.
right? Okay. Now, ma'am, you would agree with me that on page 2 of 220, that's the large letter, and if it's easier, I can approach with a different version so you don't have to keep. Okay, this might be easier for you, ma'am. This is.
Do you want these ones back?
Is that easier?
Yeah.
Okay, go ahead and keep that one, and then here's the other one. So, for example, on page 2 of 220 that you didn't write, you would agree with me that towards the bottom, you talk about your Janira putting money for you on the phone. Is that fair?
Yeah.
And that's, again, the letter you didn't write. Correct?
Yeah.
Okay. And just so I'm clear, you believe Hosanna wrote that letter.
Either her or somebody else, but it wasn't me.
Say that one more time, ma'am.
It's either her or somebody else, but it wasn't me.
Okay, so it could have been somebody other than Hosanna that would know all this,
Yeah.
but you're sure it's not you.
Yeah, well, I will tell her stuff. I'm not denying that I never wrote her,
Okay.
but these ones I didn't write.
Okay, I understand, ma'am. And nothing I'm going to say is going to change that, right?
Correct.
All right. So if we're looking at Exhibit 238, in general, you would agree that 238 is written to Janira.
Yeah.
And so somebody would have had to write 220 and just reference Janira and know that you're also writing Janira, right?
Yeah, well, she knew that.
She would know that.
Yeah.
She being Hosanna,
Yes.
but it could have been somebody else who wrote it too.
She could have somebody else do it.
Okay.
I really don't know.
All right. So let's go to the beginning of 220 and maybe we just put up 220 if we can on page 1. Ma'am, you again don't recognize that one? Fair?
No.
Okay, I'm gonna approach and just, if we could zoom in kind of right after the middle. Do you see up at the top, even being spelled E-V-A-N?
Yeah.
Do you spell even that way?
Yes, I do.
Okay. And specifically, we can zoom out of there, that's where it says, I'll always keep that promise I've been told you since day one, that's all on me. I ain't no bitch. I know all the shit that's under my belt, mamas. I'm just sorry that you're getting hurt in the process. Trust me, Ma, I do feel for you, but I'ma fix it on my truck. You're my only worry during this. I don't give a fuck about nothing else, not Evan, me. Right?
Yeah, it says that.
Okay. And you would refer to the Tahoe as your truck.
Yeah.
Okay. And then even further on that, it says, I'ma hold it down with Fetty. No matter what, don't feel obligated to be nice or think you gotta be with me because it ain't Evan, E-V-A-N, like that, Ma. You see that?
Yeah.
Okay. And then you can flip to the next page, or we can go to page 3. Do you want to look at that? Like even on page 3, approximately 9 lines down, you say, not even, spelled E-V-A-N. My own mom got that kind of hold on me. You're the love of my life, dude. I was supposed to be with you forever, right?
Yeah, it says that.
Okay. And then if we can go back to 238, and this is the one you actually wrote. Right? You see on page 2, which is really page 1, like the first page of the letter, fair?
Yeah.
You see, I guess if we could publish 238. Go down one page. And you would agree with me that approximately right in the middle, it says you can't even, and it's spelled Evan. Fair?
Yeah.
And that's the letter you wrote.
Yes.
Okay? So that is how you spell it. Fair?
Yeah.
Okay. On 220 that you're saying you didn't write, you talk about me, or it says me, Pinchy, Gordita, Hermosa. And then on page 3 at the top of the letter, it discusses that. Do you see that, ma'am?
Yeah.
And I'm sorry, Mr. Praley, give me 1 second. Can you, we have a juror with their hand raised. Give me a second. Can the parties approach? Yes. All right, ladies and gentlemen, let's go ahead and take a 15-minute recess. Give me just a moment before I let you go. I want to remind you that until the trial is completed, you must not discuss this case with anyone, either in person, using the internet, or by any other means. This includes members of your family, people involved in the trial, other jurors, or anyone else. If someone approaches you and tries to discuss the trial with you, or if you see or hear anything about it, even accidentally, please let me know about it immediately. You must not conduct any research, undertake any investigation, or otherwise obtain information about the case from an outside source. You must not read or listen to any news reports or internet information or other electronic sources about the trial. If there has been or is any news coverage of this case, you must completely disregard it. Your verdict must be based solely on the evidence presented in the courtroom and the law as I instruct you. And finally, it is especially important that you do not form or express any opinion on the case until your deliberations at the end of trial. With that, we'll be in recess until 10:40. Please rise for the jury. right, please be seated. And the court will be in recess until 10:40. Hannah? So what, oh, I'm sorry, does this need to be on the record? Oh, the copies? Sure, can you grab those? Penna, so what so I'm gonna try and push this till about 11:15 and then and then as soon as you take her down, our other stuff that we have this morning, you can bring all that straight up. Okay. I don't know. I assume that's not you doing it. About 11:50. Oh, are you doing it? Okay, yeah. And then we'll get through them as best as we can. We go grab my. Jenny, are you all set? Okay. All right, we are back on the record in 21 CR 2296, People of the State of Colorado versus Stacy Rodriguez. The parties are present as previously captioned. We are outside of the presence of the jury. We'll go ahead and bring the jury in and we will proceed.
Please rise for the jury.
Thank you. Please be seated. Mr. Prele, you may resume.
Thank you. Ma'am, where we left off, we were dealing with 238 in the middle of the page. You wrote, I miss your fine ass, bebecita hermosa. You see that?
On the yellow page?
No, ma'am, on 238. That'd be the white one that you admitted to writing?
Yeah.
Okay. And you would agree then, comparing that to 220, that would be the note that you're saying you did not write, that on page 2 it says, me, pinchy gordita hermosa, on that one, right? On page 2?
Yeah.
It's at the top of page 3 of your letter, again, referring to hermosa. And specifically, me gordita hermosa. What's that mean?
I'm not really sure.
Not really sure?
Yeah.
And then again on page 6 of 220 that you're saying you didn't write, dealing with my gordita hermosa again. Is that Spanish, ma'am?
Yeah.
Do you know what it means?
Which part?
Mi gordita hermosa?
No, not really.
No? But what's hermosa mean?
I'm not sure how to explain it.
Okay. Well, in 238 you wrote it, right?
Yeah.
So why'd you write it?
It's kind of like a nice.
Like an endearing term?
Yeah, but I don't know how to explain it.
Okay. But you wrote it in 238, right?
Yeah.
And you would agree that it's found multiple times on 220 that you didn't write?
Yes.
Okay. And then I guess we could skip ahead. For example, on 238, that's page 2 of 7. That's your first one. LMFAO.
Yeah.
And you wrote that letter, right?
On the 238.
238, ma'am, just to be clear, is the one you admitted to. That's the white one.
Yeah.
Okay. And you discuss, I hope you like this drawing. And then you do the LMFAO.
Yeah.
After you say, I just want you to show off my last name like no other, LOL, call me corny, LMFAO. What's that stand for?
LMFAO.
What's that?
LMFAO.
Yes.
Laughing my fucking ass off.
Okay. Why are you shy to say that? Are you shy to say that?
No.
I'll allow the question, given the witness's answer. And I'm sorry, Ms. Rodriguez, can you repeat that answer?
Laughing my fucking ass off.
Okay.
Fair to say that you say that throughout this message that you wrote on 238?
Yeah.
Okay. I mean, it's in a variety of places.
Yeah.
Okay. You understand that it's in a variety of places on 220 as well?
Yeah.
That's the one you didn't write?
No.
So somebody would have to know that you write that and then flood it throughout the letter, right?
Yeah.
What about SMH?
Yeah.
What's that stand for?
Shaking my head.
Okay. And so on the white one, 238, for example, let's just go to page 2. We can go ahead and publish 238. Approximately middle down here, we have shake my head. See that?
Yeah.
See it? You wrote this one, right?
Yeah.
And there's references to that on throughout this. Yes, multiple pages.
Yes.
Is it surprising to you that on the other 220 that you're saying you didn't write, there are approximately 5 times?
Yeah.
I mean, on page 3, there's 2 of them. If we could go to page 3 of 220. Remember seeing in that it says, so I heard about that fake ass blue baby you dumbass lady made. I broke that shit apart with her ugly STD, have an ass, go get one, bro. Cause these bitches, she fucked you something, SMH. Right?
Yeah.
Okay, but again, you're saying you didn't write that.
I did not.
Okay, and then at the bottom of page 3, it says, I don't know why, because clearly you don't give a fuck, SMH, right?
Yeah.
And then at the bottom of page 6, right above where it says baby joker, it says, I miss you so much, stupid, I hope you miss me too, shake my head, how you holding up?
Yeah.
And then it goes on to say, I hope well because I know you not a little bitch, and this female saying you would be on some shit in her room said it was cause all the shit I put you through. Is that true? Right?
Yeah.
But you didn't write that.
No.
Okay. In terms of, we just read this aspect of STD, right? You saw that?
Yeah.
Okay. Is that something you say a lot?
Kind of.
Okay. I mean, did you write it in 238? That's the one you admitted to writing, right?
Probably.
Okay.
What page is it on?
Well, the STD on, let's go page 4 of 7. At the very bottom. You see where at the bottom of page 4 or 7 that it talks about, I ain't trying to do nothing with them, LOL. The day I do some shit with one of these nasty little hoes is the day I lose all self-respect for myself, LMFAO. I swear that's when I lose myself, and that's not me no more, but I highly doubt I would ever, LOL, like these hoes be nasty, ASF, STDs have an ass, putas compared to you. These bitches make me want to throw up, LMFAO. And again, we've transitioned from page 4 to page 5. Right?
Yeah.
So you would agree with me that we've just looked at 238 that you wrote. It deals with these other nasty little hoes, STD asses. And then on 220 that you're denying that you wrote, that same information's in there calling people that.
Yeah.
Okay. But you didn't write it.
I did not.
Okay. What about low key? Do you say that in a lot of your writings?
Sometimes, yeah.
Sometimes? What's that mean? Like you're low key?
No. I don't know. It's kind of hard to explain. Like,
Well, who would be better to explain your own writings than you?
like not really. It means
Not really?
kind of. I don't know how to explain the word. Like,
Okay.
I know how to use it as a sentence, but
Okay. Well, why don't we deal with this then on 238? If we could go to page 3. That's the white one, to be very clear. Okay, and just to reference here, You see low key there, and then again low key here.
Yeah.
I'm low key going crazy, LOL. Not like for real, but you know, kinda, LOL. See that next sentence? Are you looking at it, ma'am? It doesn't look like you're looking at it.
I can see it from over there.
Argumentative.
All right, he can direct the witness to the exhibit.
I see the whole screen behind you.
Okay, perfect. Just want to make sure you're following along. You see that it says, I like to send letters because I could say everything without getting shy, LOL. Right?
Yeah.
And then you see just where in this, you would agree with me that there's this discussion of you specifically thinking about that night at Banditos when I had my hand on your waist. I was over there walking like I was that MF inward El Chapo. LOL, all eyes on me and everything. I have never in my life felt that MF cocky. Right?
Yeah.
Okay? And then you go to talk about that your LMFAO, you really be low key. Right?
Yeah.
Okay. And again, you wrote 238. Okay. And then going back to 220, do you remember hearing the testimony and looking at page 2 of 6 where it said, I ain't scared of none, LOL, bitch can be my number 6 under my belt if you catch my drift. Anyway, I low key ain't crazy no more. I be so calm, LMFAO. You remember that?
Yeah, I do.
Would you like to look at it?
What page is it?
Objection. I think she answered if she remembers that.
Yeah.
Okay.
And you have that, Ms. Rodriguez? You have both of those letters in front of you?
Yeah, I have all the letters.
Okay, all right. Mr. Praley, go ahead and proceed.
And so that was on page 2 of 6. Is that fair to say?
Yeah.
But again, you did not write that.
I did not.
And then on page 3 of 6, on 220, you said, go get one, bro, because them bitches, she fucked something, shake my head, happy, I ain't fuck with them, but I ain't write you to talk shit. Well, low key, LOL, because you about to make that old ass bitch get pimp handed. Is she quite being scared, LOL, right?
Yeah, it's there.
Okay. Throughout these letters, you would agree with me that there's TF written?
Yeah.
What's TF?
The fuck?
Okay. There's ASF?
Yeah.
What's that?
As fuck.
And you would agree with me? They're in both letters?
Yeah.
Okay. Throughout these letters, there's a discussion of stupid little hoes, ugly little hoes, nasty little hoes.
Yeah.
Right? I mean, for example, on page 3 of 238, you write that?
Yeah.
And you would agree with me on 220? That's contained throughout it?
Yeah.
Okay. But you only wrote one?
Yes.
Objection asked and answered.
I'll allow the question.
Talked about the STDs, right?
Yes.
You see the references in that?
Yes.
That's a pretty specific thing, right?
Yeah.
That you wrote in 238, but you're saying you did not write in 220?
I did not.
All right, what about page 4 of 7? There's a discussion that Janira had given you pictures, and there's somebody in your cell that was asking to see a picture of your lady. And so I was like, okay, OMFG, tell me why I had to take that shit out of her hands faster than you can catch an attitude. LOL, dumbass. Little hoe was drooling all over my pictures and almost had to smack the hoe. LOL, got me fucked up looking at mine like that. LOL, I miss talking to you for hours. See that?
Yeah.
So there's a discussion that that someone's looking at a photo of Janira, right?
Yeah.
That you have.
Yes.
And so somebody's at the jail, because that's where this was written.
Yeah.
And that person looks at the picture of Janira and is drooling over here and almost made you need to smack that hoe. Right?
Yeah. Didn't really happen. I kind of just said it so I could blow her head up, but
Say that again, ma'am.
I said that didn't really happen. I told her just to blow her head up.
Oh, okay. So you're lying in this letter.
Or just not lying, but playing.
Okay, just playing. Okay. And then back in 220, you agree that on page 3 of 220, you said, I ain't fuck with them, but I ain't write you to talk shit. Well, low key, LOL, you about to make that old ass bitch get pimp handed. Right?
Yeah, it says that.
You would agree that smacking a hoe and pimp handing are pretty similar
In a sense, yeah.
in a sense?
Yeah.
I mean, it deals with the fact that you're discussing in each letter the fact that somebody's going to get smacked. Right?
Yeah.
What about the N-word?
Yeah.
Do you see that in each letter?
Yeah.
Right? And you wrote 3 of 7. That's where that you were walking around like that MF N-word El Chapo, right?
Yes.
And we've already established multiple times that on page 2 of 6, where you're saying, until I started hearing shit, I wasn't hurt inward. I was like mad, right? And you would agree on page 4 that there's multiple references where you state the N-word,
Yeah.
okay? So somebody, again, you wrote 238,
Yeah.
that's the white letter, and you use that term to describe yourself, right? You wrote that out, and then we have at least 3 or 4 references in 220 of the same word,
Yeah.
okay? Throughout these, is there the discussion about hooking up with other people and fucking around on each other?
Yeah.
Okay? And you would agree you wrote the one and you're saying you didn't write the other.
Yes.
But that same topic's there throughout it.
Yes.
Okay? You sign off on 220 or at the bottom of the page, La Amor de mi vida.
Yeah.
Right? What's that mean?
I don't really know how to say it in English.
Can you try?
No, it's difficult.
Not at all.
But
You can't give it.
Asked and answered.
I'll sustain the objection.
You can't say anything about it?
Objection asked and answered.
Mr. Prelate, she said she couldn't say it, so move on.
You agree that's on page 7 of 238 at that's the final page when it says La Amor de mi vida, and then it says underneath that, Stacy Rodriguez.
Fix that whatever's being published.
Are you,
What?
are you able to spin it around? If you can't spin it around, that's fine, Mr. Prelate. That's not possible.
I mean, I think that's how it was copied, Judge, so.
Okay, all right, I'll overrule the objection.
You see that, ma'am?
yeah.
Okay. So in terms of these letters, you would agree that a person would have to, well, I guess tell me, do you believe the handwriting is similar?
Yeah, slightly.
Slightly?
Yeah.
Okay. So you agree with me that the handwriting is similar? And then just tell me yes, you agree in 220 you referenced Janira.
Yeah.
In 238 you wrote it to Janira.
Yeah.
You would agree with me that even is spelled Evan throughout both of these?
Yes.
Objection asked and answered.
I'll overrule the objection.
And so a person would have to write that throughout, know exactly how you spell this,
Yeah.
right? They'd have to use the term Hermosa, LMFAO, right?
Yeah.
Shake my head,
Yeah.
low key,
Yeah.
TF,
Yeah.
ASF,
Yeah.
stupid little hoes,
Yeah.
ugly little hoes,
Yeah.
nasty little hoes,
Yeah.
STD having asses,
Yeah.
smacking hoes,
Yeah.
the N-word,
Yes.
infidelity,
What?
cheating on people,
Oh, yeah.
right? L'amor de mi vida,
Yeah.
right? They'd have to do all that. They'd have to know all that, number one, right?
Yeah.
And then they'd have to put all that together in these notes.
Yeah.
And specifically, that's what you're saying happened.
Yes.
Your Honor, that's probably a good stopping
Okay,
point.
all right. Ladies and gentlemen, now that we're finished with the letter, we're going to go ahead and break a little early for lunch. Before I let you go, give me just a second here. I want to remind you that until the trial is completed, you must not discuss this case with anyone, either in person, using the internet, or by any other means. This includes members of your family, people involved in the trial, other jurors, or anyone else. If someone approaches you and tries to discuss the trial with you, or if you see or hear anything about it, even accidentally, please let me know about it immediately. You must not conduct any research, undertake any investigation, or otherwise obtain information about the case from an outside source. You must not read or listen to any news reports or internet information or other electronic sources about the trial. If there has been or is any news coverage of this case, you must completely disregard it. Your verdict must be based solely on the evidence presented in the courtroom and the laws I instruct you. And finally, it is especially important that you do not form or express any opinion on the case until your deliberations at the end of trial. With that, we'll be in recess in this matter until 12:30. Please rise for the jury. Thank you. Please be seated. And we'll be in recess on the Rodriguez matter until 12:30. No, and anybody that you have, you can go ahead and bring them up.
Thanks for waiting.
They sent them to the jail. We didn't.
Because we reset a couple, but I said we reset a couple, but we still need a definition, because there's a variations.
We're gonna do them now as soon as they're up here. Yeah, yeah. They shouldn't have sent everybody back to the jail. Like
Those are the, we reset years, we send them. Here's just the one that I
I'm in the middle of trial. I can't really talk. They just said that they need to gain emotion.
And I don't know what DA is gonna be here, but can you email their office and see?
Do you want to look at my?
I see Mr. Rand there.
Yeah, I'm talking to him right now.
All right. Mr. Rush, is Mr. Bolstad here?
Yes, sir.
All right, thank you. Can you put the FTR on, please? All right, the court will call 24 Did you make any headway on tomorrow morning?
I was thinking about today. I got one of the 8:30s for Dolores.
Or just do, if you don't respond, we're setting it at 2:30. Okay, because that's kind of what I'm trying to do on Friday.
I'll do that.
Maybe do 3:30.
Or 3:30.
3:30, yeah. Or did you call for Ms. Rodriguez?
Yes, I did.
So you do fine on the kennel? Yeah, nice.
Thank you.
Jenny, are we on a new tab or is it the same one from this morning? Okay. Okay. You show that I'm on? Okay. Well, I can see it. All right, the court is back on the record in 21 CR 2296, People of the State of Colorado versus Stacy Rodriguez. The parties are present as previously captioned, and we are outside of the presence of the jury. We'll go ahead and bring the jury back in and resume. Thank you. Please be seated. Ms. Rodriguez, I will remind you that you are still under oath and the state may resume.
Thank you. Ma'am, in direct examination, you were asked about the body-worn cam of your arrest on November 11th, right?
Yeah.
And again, throughout your testimony, you've discussed this social anxiety.
Yeah.
Wouldn't interacting with police cause you great anxiety?
Yeah.
On that day, did you have that?
Yes.
Do you think that's depicted very well in People's Exhibit 142?
Not really.
I'm sorry, ma'am, if you could speak up?
Not really.
Why do you say that?
I don't know.
All right, well, why don't we watch it then? Let's start with 142
Objection, cumulative.
from,
The court will overrule the objection. Mr. Praley, you can go ahead and proceed.
let's just start from 235 to 6 minutes.
So we're working on a case. Do you mind if I talk to you for a couple minutes about it? Okay. Does this person look familiar?
No,
Okay. Have you ever seen him before?
no.
Okay. Have you ever been to the Convictive Bar downtown Greeley?
Yeah, a couple times.
Okay. What do you remember when you were there last?
Maybe last Thursday?
Last Thursday? And prior to that?
I don't know. I would go often, yeah.
Okay. So you've been there often.
Yeah.
Have you ever seen this person before at the bar there?
No.
Okay. Have you ever been to 24 13 15th Avenue Court in Greeley?
No.
It's all rough, like by 25th Street, 11th Avenue.
No, where's like that? Like,
What's that?
Like the stores by there? Or?
Well, it Arson.
Oh. No.
Okay.
I go to couple like after parties, but I don't think I'm there.
Okay. Would there be any reason that you don't remember him because you were too drunk to remember him?
Maybe, I don't know.
Okay. Would you have been too drunk to say that you were been over at that house?
Maybe, I don't know. I'm not that.
You don't think you've been there? Okay. What vehicle do you usually drive? This one? Okay. Is there any other vehicles that's registered to you?
No. You can check, right?
Okay.
Yeah.
Yeah.
No, I told you this one.
Okay. And is that Hosanna?
Yeah.
Okay. Are you guys friends?
Yeah.
Okay. More than friends?
Hey.
Yes?
Yeah.
Okay. Are you girlfriends?
Yeah.
Okay.
We don't really like announce it.
Whose vehicle is this?
Just like,
Okay. What vehicle does Hosanna drive?
she has it.
She doesn't have one? Okay.
Well, I think she used to, but I don't know what happened to that. But you can like ask her.
Okay. Do you drive a Malibu?
No, I don't.
You don't? Okay. Have you ever driven a Chevy Malibu?
No. I don't know. I don't know this one.
Just this one?
I think I'm gonna have my title.
What's that?
My title, do you want it?
For the Suburban? No, that's okay. I can run the license plate if I need it. So you never driven a Chevy Malibu?
No.
Is there a Chevy Malibu registered anyone that you know? Like a silver Chevy Malibu?
I haven't think so.
Okay. Can I get your current address?
Oh, yeah.
Yeah, I talked to Stacy here. She said she doesn't know who this is. She was at Cubetta's last Thursday and maybe a week or two prior to that.
I would go up and play on.
Yeah. She doesn't believe she's ever been to the 2413 15 Avenue Court address. She doesn't know anybody who drives a silver Chevy Malibu.
No.
Is that right?
Yeah.
And have you ever driven a Chevy Malibu?
No.
Okay. What's your current address right now?
45. 40. West 3rd Street.
Would you agree with me when we've now watched a portion of 142 from 235 to 6 minutes? Would you agree that you are speaking softer today and last week when you're being asked on direct examination than you were in Exhibit 142?
Yeah. kind of, I guess.
Okay. You're quieter in court.
Yeah, there's a lot of people in here.
Okay. And so is that the reason you're speaking quieter?
Yeah.
Okay. Would you agree that you're more passive on Friday and today than you were in the video?
What do you mean by that?
Like passive, like shy.
I feel the same.
You think you're the same?
Yeah.
Well, there you're telling the officer, you can check the registration. You know how to do that, right? You're telling him what he should do, right?
Yeah.
You're asked about the Chevy Malibu, and it's your testimony today that you just don't know what a Chevy Malibu is?
No,
You don't?
I didn't.
You don't know
Just
makes
called it-
and models?
I don't.
Well, don't you think that'd be a good time to try and clarify when he's saying it's a Chevy Malibu and you're like, I don't know cars, like makes and models?
No.
You don't think that'd be a good time to bring that up?
I mean, yeah, but I didn't think about it.
Okay. What about, did you think about it when he talked to you and clarified what color it was? When he says it's silver, didn't you think, hey, maybe that car that I've been driving that's silver, that's part of my family's, maybe I should tell him?
I drive a lot of great cars. That wasn't the only great car that I was driving.
Say that again, ma'am, I'm sorry.
That wasn't the only great car that I was driving.
Okay. So you didn't think you should bring up the make and model? You don't think you needed to bring up I drive a lot of silver cars?
No.
Okay. At this time, you were around Hosanna Varela, right? Like, you guys are in that car together?
Yes.
And specifically, do you recall that at approximately 10 minutes and 24 seconds that you guys are separated, right?
Yeah.
And she's over talking to Detective Burrows, right?
Yeah.
And you can see that, right?
I seen it in Discovery, but I couldn't see it from where I was at.
Well, there's windows in this car, right?
Yeah.
You can look through the windows.
Yeah, but I didn't see her.
You didn't see her?
I did not.
If we can play clip 2 from 10:24 to 11.
Like, I knew she had walked through the back, so I didn't directly see her.
You didn't directly see her. So you don't know if she's talking to Detective Burrows? Is that your testimony today?
Yeah, I don't know where she was at.
Okay, if we can play 10:24 to 11.
Can you get out of the wind just a little bit?
If we could pause it right there. Is it your testimony today that you are not facing back towards the back of your Tahoe?
Yeah.
And there's windows in that car, right?
Yeah.
And you would agree with me that Hosanna Varela and Detective Burrows would be that side?
Well, she got off on that side, but I don't know if she was standing there.
Okay. If we can keep playing.
What are they telling her?
I can't hear her.
Did that help refresh your memory at all?
I don't remember seeing it.
Well, you just saw it though, right?
No, but
Objection argumentative.
All right, I'll allow the question.
Did you just watch it?
yeah.
Do you agree that you're facing their direction?
Yeah.
Do you agree that you said, what are they telling her?
Yeah.
And then you hear Detective Hunziker say, I can't hear.
Yeah.
And your testimony is still that you don't know that they're talking because you can't see Detective Burrows and
Well,
Hosanna?
I knew that they were over there, but I didn't see her, like, physically. Like, I don't remember seeing her over there.
But you specifically said, what are they telling her?
Well, I knew that she was over there because they took her around that way.
Okay,
But I didn't physically see her body.
okay. All right. And again, you've previously said that there's just this mutual agreement that you guys have to keep quiet and not tell the police at this point, right?
Yeah.
And that's just something that you had felt in general because you valued her life,
Yeah.
right? But then you're asking what they're talking about,
Yeah.
right?
Right.
And again, Detective Hunziker tells you, I can't hear what they're saying. But you got to watch it, right?
The
In
video.
this trial,
Yeah.
right? And you know what he is telling her, right?
Yeah.
He being Detective Burrows. He's outlining the charges to her. Is that fair?
Yeah.
And he's asking the same questions that you're getting asked.
Yeah.
And so you know the answer now, right?
Yeah.
You talk that this agreement just came out,
Yeah.
that you guys would keep quiet. And you knew from October 3rd on that you had stabbed Christopher Dickerson 5 times in the throat, right?
Yeah.
That you had taken his stuff,
I did not.
okay? You didn't know that?
I said I did not take it.
Okay. That you had gone back and burnt his house down,
Yeah.
burnt his body, and you knew that.
Yeah.
And during this time period, you'd agree with me that you're sending notes about they'll kill a MF for you, 6 feet under, no joke, right?
Yeah.
And all that's happening before we're seeing this,
Yeah.
right? And then you discuss having social anxiety on this day, specifically in this body-worn cam,
Yeah.
right? And you agree to this jury that this video that's fair and accurate makes it look like you really don't care.
Yeah. The battery that was in my hand helped a lot.
The what?
Battery?
The battery in
There
your
was
hand?
a battery that was in my hand.
Okay. And that helped make it look like you didn't care?
No, that helped with the anxiety.
Okay.
So it was more.
So you were just holding a battery
Yeah.
in your hand, and so that that reduced your anxiety?
Slightly.
Okay. So then, when you're informed of the charges at 11:10, maybe we should just play it. Let's go ahead and play it. From 11:10 to, say, 11:56.
Is there a question?
I'm sorry, Mr. Pirelli, can you pause it?
Sure.
Mr. Hio, I couldn't hear you.
Objection, is there a question, or are we just?
So he can refer the witness to the exhibit and then ask questions after that.
What you're arrested for? Being arrested for first-degree murder, arson, burglary, and tampering with a deceased body. Okay.
Is there proof of that?
Yes. Okay. You want to talk to me? I'll hear your story. I'm going to talk to you. Okay. It's up to you. You don't have to talk to me. But if you want to tell me your story, I'll listen.
So, ma'am, after being informed of first-degree murder,
Yeah.
you responded, yeah, right?
Yeah.
Arson,
Yeah.
tampering,
Yeah.
and burglary.
Yeah.
Your response was what?
Is there proof of that?
Objection, we just watched it.
All right, I'll overrule the objection.
And you're telling this jury that you had social interaction or social anxiety right then?
Objection, badgering, at this point, we've talked about the social anxiety at length.
All right, I'll overrule the objection.
Yeah.
Yeah?
Yes.
That's what you want this jury to believe.
Well, I knew that it was happening.
You knew what was happening.
Social anxiety.
Okay. And your response to it is there proof of that after being told that you murdered someone,
Yeah.
that you burnt their house down, burnt their body down, and took their stuff,
Objection, asked and answered.
right?
Overruled.
Yeah.
Those are my questions at this time.
All right, thank you. Any redirect examination, go ahead.
Yes, thank you.
All right, Stacy. Social anxiety happen when you're alone?
Not really.
Is it usually when you're around a bunch of people?
Yeah, like a lot of them.
Do you usually get pretty anxious when you're in new situations?
Yeah.
Give me just a second. I'll sustain the objection, and Ms. Trujillo, if you want to rephrase that, go ahead.
If you're in new situations, do you get anxiety?
Yes, I do.
Do you get anxiety if you're in new situations involving new people?
Yeah.
Do interactions with police for you kind of start that anxiety?
I'll allow the question.
I can re-ask it. Do interactions with the police kind of start that anxiety for you?
Yeah.
Has it always been this way?
Yeah.
Was your social anxiety a little bit different when it was just you and Hosanna together?
Yeah.
Why?
Well, I mean, I was comfortable with her.
Okay. So with social anxiety, did that really come into play when you guys were driving to the gas station?
Leading.
I'll allow the question.
Did social anxiety come into play when you guys were going to the gas station on October 3rd?
Not really,
Why not?
because it was just me and her.
Okay. Now we talked, well, the prosecution talked a lot with you about those letters.
Yeah.
Okay. In those letters, you weren't discussing what happened with Mr. Dickerson, right?
No, I was not.
In those letters, were you embarrassed when the prosecution was reading them out loud?
Yeah.
Why?
Well, for one, it's because I didn't write them, you know, and I don't know, just the things that says in there, you know.
Do you think it would have been, well, I guess if it was embarrassing, why didn't you just say you wrote them?
Because that's not what I did.
I want to kind of just maybe talk a little bit about what the jail is like for, people that don't know. You mentioned in the letter that you did write to Janira. Do you know what I'm talking about?
Yeah.
And there was a drawing in the back of that. Do you know what I'm talking about?
Yes.
Okay. And you told Mr. Pereira that you didn't draw that, right?
Yeah.
Did somebody else draw that for you?
Yeah.
Would that happen often in the jail?
People drawing stuff for me?
Yes.
Yeah, somewhat.
Okay. Would it happen often that, some people's handwriting, for drawings or, people would just kind of share that type of stuff?
Objection, leading.
Yes.
Give me just a second. I'll allow the question. Ms. Rodriguez, can you repeat your answer, please?
Yes.
Okay. Would you consider the jail to be a private place?
No.
Okay. Do oftentimes people know who you're writing?
Yes.
Do oftentimes people know what you're writing about?
Yes.
Was it possible for other people to see letters that...
Objection calls for speculation.
I'll allow the witness to answer the question.
Was it possible for others to see maybe letters you were receiving?
Yes.
And was it possible for others to see letters you were writing?
Yeah.
Now you did write Hosanna letters in the jail?
Yes.
And why are they different than the ones that the prosecution is suggesting you wrote?
Because the ones that I had wrote her were brief.
Okay.
I think the longest one that I had wrote her was a Bible verse, but that's it.
Okay. Now we heard a lot of the language that was used in the letter that you write to Janira. Some, would you agree, or were there derogatory or kind of offensive words in there?
Yeah.
Were you meaning to offend anybody?
No.
How is the way that you're talking in the letter that you wrote to Janira different than the way you're talking to the jury?
I'm a lot more comfortable with Janita, so I can talk in different.
When you're talking to the jury, are you embarrassed to use swear words?
Yeah.
When you're talking to me, are you embarrassed to use swear words?
Yes.
You and I have been working together. Have we been working together for a while?
Yeah.
All right. Just one moment, please.
Sure.
Okay. So let's go to kind of the morning of October 3rd when you're in Mr. Dickerson's house, okay? The prosecution had kind of talked about I think Mr. Pralia had called it a tricep exercise. Explain to me kind of what you were thinking about when you had stabbed Mr. Dickerson. What was going through your mind at the time?
That he was going to kill me.
Were you able to see him when you initially hit him with the metal file?
The last time?
No, when you first did.
No.
And why not? Can you explain that to the jury, please?
So I wasn't looking.
Sorry, can you say that again?
Because I wasn't looking at him.
Okay. Why weren't you able to look at him? Or why weren't you looking at him?
Because he grabbed my face and I didn't want him. I just wanted to get away, but at the same time, like, stop him,
Okay. At one point, you testified that, you had the handle broke because you had put all your weight on it. At that point, were you facing Mr. Dickerson?
Yeah.
Okay. Can you explain to me how that changed?
I had sat up.
Okay. And did you move over?
Yeah.
When you sat up, what was Mr. Dickerson doing to you?
He was still grabbing me.
Okay. How?
My shirt.
By your shirt? Okay. Like on your chest?
Yeah, more like right here.
Okay. When you had sat up and turned around and he grabbed your chest, did you feel like you had any other option?
No.
Did you want to put that metal file in Mr. Dickerson's neck?
No.
Did you want to do that 5 times?
No.
Were you even aware it was happening?
No.
Now let's back up a little bit, still kind of with the same topic. When you and Mr. Dickerson are on the couch, you had mentioned throwing a beer bottle. Do you remember talking about that?
Yes.
Okay. And the prosecution had asked you if that bottle broke, right?
Yeah.
Can you just kind of explain how you initially grabbed that bottle?
I was trying to reach it with my fingertips first, and then little by little it was scooted closer.
Where was the bottle?
On the floor in front of the couch.
On the floor, you said, by the couch?
Yeah, right in front of it.
And then when you grabbed the bottle, how was Mr. Dickerson holding you?
Right here, is that I don't know what this part's called.
Your arm?
Yeah.
The upper part of your arm? Did he have both hands on each side of your arms?
Yes.
Okay. And so when you grabbed the bottle, did you have free range of motion?
No.
What did you do with the bottle when you grabbed it?
I threw it, and then it went over him.
Okay. Did you ever grab a broken piece of bottle?
No.
Did you ever grab another bottle?
No.
Did you ever hit Mr. Dickerson on the head with a broken piece of bottle?
No.
Now, you talked with Mr. Paralia about the blood and kind of what Hosanna had said also about the blood. When you saw Mr. Dickerson, after you had kind of gotten on top and after the handle had broken, did you see blood?
Yeah.
Was there was that something that stuck out in your mind?
Seeing that? Yeah.
Did you kind of get stuck on that fact?
Yeah.
Can you explain how?
How it happened?
No, how you got stuck on it. You know what I mean? Can you explain that emotion to me?
I felt like I just felt frozen, I don't want to say an out-of-body experience, but I felt like I couldn't feel my body.
Okay. Where did you see the blood on you?
My hand.
Is that why you put the glove somewhere else?
Yeah.
On the other hand?
Yeah.
I'll allow the witness's answer to stand.
Let's talk about darts. Did you know what Mr. Paralia was talking about when he brought up the darts to you?
Kind of.
Kind of. What didn't you understand? Just what darts are?
Yeah.
Okay. When you were with Mr. Dickerson and you were defending yourself, Did you think about where the metal file was going?
No.
Did you intend for it to kind of hit the same spot?
No, I kind of was just, it was in the same motion.
Yeah. When you had the file in your hand, did you flip it around or decide what end to use?
No.
How did it happen? Can you just say, like, can you explain, like, when you had it and then when you used it the first time?
Honestly, I just grabbed and then like everything just happened so fast. Like,
Mr. Prillia had brought up the living room door with you. Do you remember testifying that you kind of struggled with the door handle?
yeah.
Okay. Why were you struggling with the door handle?
I think it was the emotions that I felt at the moment, like panicked, and I feel like my hands just went like I couldn't control them and I couldn't.
Sometimes when you're nervous or panicked, your hands shake.
Yeah.
Has that been happening throughout your testimony?
Yeah.
Is it something you can control?
No.
Thinking of that, let's talk about the battery real quick. I know we're kind of jumping, but you had said that the battery in your hand in the car on November 11th helped you. What do you mean by that?
Like just kind of like fidgeting with other stuff. I feel like helps a lot with my anxiety.
Okay. When you were there and you were with Detective Hunsinger and Detective Burrows that we saw in that video, was it the social anxiety that led you to lie?
Yeah.
Okay, in what way?
I feel like just like what police in general, you know, they just give me anxiety. So.
Okay. So that was November 11th, 2021. You know, it's been a few years. Have you ever, I mean, how do you feel about lying now?
I feel bad about it.
Why do you feel bad about it?
Because I should have tried to tell the truth about what happened.
Okay. Okay, I apologize for jumping around, but I want to go back to the house, okay?
Okay.
So, fidgeting for the door handle. When you were at the door, did you know where Mr. Dickerson was?
No.
Okay. When did you know that, I mean, when were you aware of where he was when you were at the living room door?
When I turned around to look at Hosanna.
Okay, is that when you turned around to push him away from Hosanna?
Yeah.
When that was happening, did Mr. Dickerson seem like he was falling over drunk?
I mean, I think he got a pretty good grip on her, so I don't think so.
Let's go when you guys were in the kitchen and you had pushed Mr. Dickerson off of you. You testified on direct that he had kind of grabbed onto the fridge, right?
Yeah.
Do you remember that?
Yes.
Okay. When he was grabbing onto the fridge and afterwards, did you feel like he was, you know, kind of uncontrolled, like didn't have control of his body?
Yeah, I think that I had caught him off guard.
Okay, it caught him off guard?
Yeah.
Did you think it caught him off guard because he was so drunk?
I think it's because obviously like him being a man, he overpower a girl, so I don't think and then especially because he had to look back to look at her, and then it just came out of nowhere.
Okay. What happened between you and Mr. Dickerson that night? Did that have anything to do with him being a man and you being a woman?
I mean, I wouldn't necessarily say that.
Okay. You didn't do what you did because he's a man?
No.
Okay. When he had grabbed onto the fridge and you and Hosanna are going to the living room, did you hear him coming to the living room?
No.
Okay.
Like, I wasn't paying attention, but also there was music playing. So either way, I wouldn't have.
Okay. Okay. Did you feel when you were with Mr. Dickerson that he overpowered you?
Yeah.
Did you feel that he was, like, whether or not it was he was too strong or strong enough, did you feel that, you know, when he was on top of you, you couldn't overpower him?
Yes.
Okay, just one moment, please.
Sure.
Ms. Rodriguez, is there anything else that you were feeling about that night that you feel like has not been conveyed?
No.
No. Okay. Do you feel that when we're talking about, you know, you going back in the house and the prosecution had said you were the only one, are you trying to pin the arson on Hosanna?
I'm not.
Are you trying to get away with anything?
I'm not.
Why? Tell me what do you mean by that?
I feel like if I was trying to get away with it, like, in all reality, whatever happened inside the house, like, only me and Hosanna know. Yes, they have surveillance, but they only have it on the outside. If I was trying to get away with this, I would deny everything. And that's not what I'm doing today.
Okay. Thank you.
All right, thank you. Ms. Rodriguez, you can go ahead and retake your seat next to your attorneys. From the defense, you may call your next witness.
Your Honor, if we could approach.
Sure. All right, thank you. Ms. Trujillo, does the defense rest at this time?
Yes.
All right, thank you.
Can we just have a moment?
Yes, go ahead. Mr. Praley, like if it's like 10 minutes, I'll go ahead.
It'll be much less than that.
Okay, all right.
We're ready.
All right, thank you. Mr. Praley and Mr. McCormick, does the state have any rebuttal evidence?
We do not.
All right, thank you. Ladies and gentlemen, the evidence in this case has been completed. I need to speak with the attorneys about some scheduling matters going forward. So what I'm going to do, I'm going to send you back in the jury room for a break. I'm going to ask you if you can remain in the jury room just while I have that conversation with the attorney so I can know at what point it's reasonable for us to get back started. And then I'll inform you of that as soon as I know. So before I let you go, I want to remind you that until the trial is completed, you must not discuss this case with anyone, either in person, using the internet, or by any other means. This includes members of your family, people involved in the trial, other jurors, or anyone else. If someone approaches you and tries to discuss the trial with you, or if you see or hear anything about it, even accidentally, please let me know about it immediately. You must not conduct any research, undertake any investigation, or otherwise obtain information about the case from an outside source. You must not read or listen to any news reports or internet information or other electronic sources about the trial. If there has been or is any news coverage of this case, you must completely disregard it. Your verdict must be based solely on the evidence presented in the courtroom and the law as I instruct you. And finally, it is especially important that you do not form or express any opinion on the case until your deliberations at the end of trial. With that, I'll ask if you remain in the jury room, and we'll bring you back in just as soon as we can. All right, please be seated. All right, I've already received a Word document with the state's proposed instructions. Is the state intending on submitting anything additional apart from what it's already sent over?
No.
All right. Ms. Devereaux, Ms. Trujillo, how much time do you need before you get me your proposed instructions?
I can be quick. Is the court willing to give us a little bit of a break to do that?
Sure, I'm happy to do that. I'm just trying to figure out scheduling. So here's the main sort of thing that I can't really move or work around depending on how things go the remainder of the day. I have a 2-hour sentencing hearing tomorrow at 10 a.m. on a leaving the scene causing death with a number of different people coming in, and I can't realistically move that sentencing hearing. If we're able to at least get to the state's first closing argument today and finish closing arguments on tomorrow morning, I think that would probably work. I just kind of need to know from the parties right now when's reasonable for me to bring the jury back while we hammer out those jury instructions.
I could have about, is 30 minutes enough for me to get you the jury instruction, or is that too much time?
I think that's reasonable. If I tell the jury to come back at 2:30, does that, Ms. Devereaux, Mr. Hio, does that sound about right to you?
To start closings?
Hopefully to start soon after that.
Yes, that should be fine.
Mr. Presley, Mr. McCormick, does that sound about right to you?
I don't know with the jury instructions. I know last time they took much longer than I expected in the sweat trial. What I really want to prevent is us not being courteous of the jurors' time when we're already this far in and having them come back and wait for something that is going to take much longer. So
my other alternative is to bring them back tomorrow, but unfortunately, realistically, that would be at like noon tomorrow. Because as I stated, I can't realistically move that sentencing hearing that's scheduled from 10 to noon, and I don't think 8:30 to 10 is probably enough time for closings.
Can we do what the court suggested, do the state's first closing, and can the court then tell and explain to the jury about that prior situation?
Well, if we do the state's closing, I have until like 8:15 to 10, so that I have time in the morning. It's just that 10 to 12 block that I can't move.
Right.
You have time tomorrow afternoon, is that what you're getting at?
I do have time tomorrow. I could send them home now and bring them back at noon tomorrow. I hate to excuse them for that long, but I think it's likely we're going to have them come back tomorrow anyway. So if the parties agree, I can do that as well, and then we shouldn't be rushed on jury.
Would we be able to go, once we start at noon, can we finish it?
Yeah, we'll have to move some stuff, but yes.
I think my preference is to keep it together, even if we have them come back today for reading of the jury instructions and then closing right at noon tomorrow.
If I was going to bring them back at noon tomorrow, I probably would just send them home now rather than make them sit around a couple hours and then just read them instructions and go. But I think we can probably figure that out.
And that's fine. If the court wants to do it that way, then we're not rushed to get these instructions done while they're waiting.
And Ms. Devereaux, and I'm sorry, you were about to say something, Ms. Devereaux, and then Mr. McCormick, I'll get to you. And I'm sorry, were you about to say something?
I was talking when Mr. McCormick interrupted me. What I was saying is I understand on one hand, the prosecution's like, let's just get it all done tomorrow afternoon. But this jury has been here and now is going way over it. And I just feel like it's kind of a slap in their faces to be like, we're not going to do anything the rest of today or tomorrow. We'll see you back here in 24 hours. And so I would ask if we could just at least, I don't think jury instructions are going to take that long. I don't. And so I was just asking if the court would do its first suggestion, which is have the state do their first one. We come back tomorrow morning. And if the court could tell them, like, this isn't the party's fault, so to speak, like I have another court situation from these 2 hours, just so that they're not thinking we're wasting their time is my biggest concern.
And Mr. McCormick, anything else?
Well, I didn't mean to interrupt Ms. Devereaux, but I was going to suggest the same thing. At least if we're going to go until noon tomorrow, can we give them an explanation as to why it's taking this?
Sure. All right. So what I'll do, I think the most reasonable thing to do is to, because I don't think there's any scenario where they don't come back tomorrow anyway. I'm going to explain to them the situation and explain to them the other matter that I have tomorrow morning. And I will release them until noon tomorrow, and then we should have everything finalized by then and be able to proceed straight through. And Ms. Trujillo, with that, what I would propose then is that in this case, we'd stand in recess until 2 p.m. to give you a chance to get everything together and emailed over, and then we'll begin discussing jury instructions at 2 p.m. And then we'll have to figure out the afternoon stuff when we figure it out, the rest of that docket. I know you're thrilled about it. All right, let's go ahead and bring the jury in. I will give them that schedule and we will proceed. All right, please rise for the jury. All right, thank you. Please be seated. All right, thank you. Ladies and gentlemen, I appreciate your patience while I got the scheduling thing figured out. So, ladies and gentlemen, first off, I really appreciate your patience throughout this process. I know it's been even a longer trial than we anticipated, and I know that that's caused many of you, if not all of you, some inconvenience on that. I just want to explain exactly what's going on here in the interim while we have a couple things to figure out. So, I know that you've heard me refer to several times over the course of the trial to your jury instructions. It's at this point in time where I need to have a legal discussion with the parties to finalize the wording and the length of those jury instructions that will be given to you at the close of trial. That conversation I anticipate is going to take a little bit of time, and so that's why I needed to go over scheduling so I didn't have to keep you guys here while you waited on what's probably going to be a fairly lengthy discussion. The long and short of it is that I am going to bring you back tomorrow for closing arguments. Now, unfortunately, because we're going longer than I anticipated, I have a sentencing hearing tomorrow morning on an unrelated case that's also from a very serious situation that I anticipate there's going to be many family members appearing for that sentencing hearing tomorrow morning. So unfortunately, that's not something that I can reasonably move and be respectful to that separate situation. So what I'm going to do, the parties are going to work at finalizing jury instructions. I'm going to release you for the remainder of the day. I'm going to have you come back at noon tomorrow. At noon is when that sentencing hearing is scheduled to be concluded. And then at that point in time, we should be able to proceed straight through my giving you your instructions, the parties' closing arguments, and then turn the case over to you for your deliberations once that's complete. So again, I apologize for any inconvenience that may cause to you. I'm just trying to sort of juggle a number of different things and try to minimize your wait time here in the courthouse as much as possible. So with that, I am going to release you until noon tomorrow. Again, if you'll just come directly upstairs, and then we should be able to start just as soon as that sentencing hearing finishes. And before I let you go for the evening again, I want to remind you that until this trial is completed, you must not discuss this case with anyone, either in person, using the internet, or by any other means. You must not conduct any research or undertake any investigation or otherwise obtain information about this case from an outside source. Your verdict must be based solely on the evidence presented in the courtroom and the laws I instruct you. And finally, it is especially important that you do not form or express any opinion on the case until your deliberations at the end of trial. So with that, we will be in recess until noon tomorrow. Please rise for the jury as they leave. All right, thank you. Please be seated. All right, we'll be in recess until 2 p.m., and then we will begin discussing jury instructions. Mr. Heel, Ms. Devereaux, if you could, once you have those, if you could email me a Word copy of those without track changes, just so that I can edit those as we go. And then you certainly may have a conversation with Ms. Rodriguez, whether she wants to be present or not for that portion of the proceedings. And if she chooses not to, she has my authorization not to, if that's her decision.
Thank you.
All right. And the stuff we moved at 3:30, is that?
For this afternoon?
No, tomorrow.
Tomorrow, we have not moved anything.
Okay.
I'm checking with Candy to see if there's a judge that can take our 115s or 130s, because that's all we have left.
Yes.
And it's
So
basically
we-
3 defendants.
If we start the meeting on time, probably get done by like 3:30, and then we can make cases after.
You're gonna push them things to 4.
I thought that's what Melissa was already going to do, but if she hasn't done that, did she already do the morning?
Well, we were working on all of it. We got Dolores Herrera done.
If you haven't heard back on the rest of the morning between 8 and 10, just email everybody back real quick and say, never mind, or have that time so we can do all those as scheduled. And then, if Candy can't find another judge to do tomorrow afternoon, we'll push it to
Maybe I can see.
but send the morning email first and let them know. Never mind, I'll keep everything from 8 to 10. Where it is.
Yeah. What I could do is offer the 8:30 slots. 1, 2, 3. I'll talk to Cheryl. We can make it fit.
Yeah, that'd be great.
If anybody could come in early, yeah. If they can. If they can't, just let them know whatever you delay.
That'd be great. Oh, thank you.
It'll have to be physically, just like today. Just delay. All right.
Here's from my phone case.
Is it
Plug
both?
into the charging desk, yeah. Make her a little area, thank you.
Are you gonna?
Yeah.
Oh, then come on, come back. Okay.
I'll grab my stuff. Hey, bro. I'm gonna go help with you adjust this.
And Jenny, we can do this next part on F.
Thank you very much.
Thank you.
Oh, thank you.
Yeah, I had to do the same thing, I've had to do it every year.
Sorry, you're good.
Feels it tough.
That is a.
Very, very. No one wants a mediocre.
Because our black lab is rude.
Crazy.
I can turn WebEx off, right?
Yes.
Okay.
Yes. No, we need to, yeah. I mean, we could do Thursday, Thursday,
And Ms. Devereaux, Mr. McCormick, can you tell me, are you okay with doing the jury instruction conference on FTR? If so, I'll go ahead and let Jenny get out of here.
I don't have an objection, so as long as it's on the record in some form.
Yes, it'll be on the record on FTR. Mr. McCormick, is that fine with you?
That's fine, no objection.
All right. Jenny, if you want to pack up, you can pack up whenever. All right. Thank you for your help. Hey, when it gets to 3, maybe put your WebEx on just on your computer, just in case any victim reps come on any of those. And if you see people on, just put something in the chat. Beat the wait. Yeah. Perfect. Thank you again, Jenny. right. We have FTR on. Okay. Mr. Praley, did Mr. McCormick just step out, or are you going to be the one here doing the instructions?
He did step out in
Okay.
order to print the defense that just got.
Sure. Okay.
Oh, I couldn't print them for you. Thank you.
Jenny left. I assume you don't know your job.
What?
If you wrote FGR.
Oh, no, yeah, that's fine. Some just more than others. That's funny. I'm so quick up there.
I'll make a new one. Reset this one. And then he's done, so I just. I'll put you off. You just. No, okay, thank you.
All right, we are back on the record in 21 CR 2296, People of the State of Colorado versus Stacy Rodriguez. Ms. Rodriguez appears today with counsel. Oh, I'm sorry, Ms. Trujillo. Did we lose Ms. Devereaux?
We're okay to continue.
Okay. Ms. Rodriguez appears with Ms. Trujillo. Mr. Praley and Mr. McCormick appear for the state. We are outside of the presence of the jury and are commencing our jury instruction conference. The court has received a packet of proposed instructions from both the state and the defense. I'm going to start by going in order in the packet. So the first instruction, and I'm going to refer to the state's packet for convenience sake here, although I think largely the parties have most of these instructions in the same order. As to the first instruction, Mr. Hio, is your instruction identical to the state's?
Yes, I just added ours in, if that's helpful too. So
Sure.
the first instruction is the same.
I did make one change to both of the parties' instructions on reviewing the latest version of the Colorado criminal jury instructions, which this instruction largely tracks except for a couple of places. So the paragraph that I added is after the paragraph beginning with during the course of the trial. The paragraph that I added reads, you must also not be biased for or against the defendant, any witness, or any other party based on any identifying characteristics such as race, religion, age, gender identity, gender expression, sexual orientation, ethnicity, national origin, disability, socioeconomic status, or any other such characteristic. You must not allow bias to influence your verdict. I also added one line towards the end of the instruction as indicated in the stock instructions, given that I believe I asked the question of one or two witnesses during the trial. That addition is right before the final paragraph, and that reads, if I have asked questions of witnesses during the trial, that did not mean I had any opinion about the facts of the case. From the defense, do you have any objection to me including those two additions?
No.
Anything from the state? Do you have any objection?
No.
Okay. All right. Then I will include those two additions to closer track the model instructions. The next instruction that I have in the state's packet is the charging instruction. Ms. Trujillo, I think yours was identical. Is that correct?
Yes, it is.
Okay. All right. Then I will submit that to the jury. Give me just a second.
And Your Honor, I apologize. To go back to the page 1 of 2 on the general one. We had, just to be clear, for the record, we had used all of these in the SWET trial.
Yes, and I honestly, I didn't notice that paragraph was missing until I was looking at them just now. I just thought.
And that socioeconomic status, that's on page 2 of 2, just at the top of the people's, the unconscious bias.
Oh, so the new model instructions, the 2024 version has a separate paragraph on that now. Oh, here, let me pull it up.
I'm sorry. What number is it, Judge?
It is, give me just a second. E01.
Okay. As long as the court wants to use that, that's fine. I just wanted to say that on that page 2 of 2, that's where it discusses that race, religion, age, gender.
Yeah. Yeah, it looks like the new version has one discussing both bias as well as implicit bias. So given that it had that additional paragraph, I did think it was appropriate to include.
Okay, thank you.
All right. And I'm sorry, Mr. Hio, you said that the charging instruction was identical, is that right?
Yes.
Then I will consider that one approved. Next instruction to address is in the defense packet, the theory of the case instruction. Mr. Pereira, Mr. McCormick, can you give me the state's position on their defense theory instruction?
Yeah, I can tell the court that I think it's the obligation of the court to help craft one. I think this is entirely too detailed in terms of what is involved in it. I think there are several things that need to be taken out. I don't think it needs to be this long. I don't think it should mention prison shank. I don't think it needs to talk about the countless souls. I think it can be modified. I agree that they ultimately get one. But I think this is incredibly voluminous and too detailed, argumentative, and therefore I think the court needs to work with the defense to craft one that you believe is appropriate.
So let me just go in order here. So the specific language that you have concerns about, number one, the use of the term prison shank, I got that. Number two, the use of the term countless souls, I got that. Is there any other specific record that you'd like to make regarding a specific language in there?
Well, yeah, I mean, I think you go from, I think you could have the first sentence. I'm not objecting to the first sentence. I don't believe that it needs to get into the corner, pushed him off, didn't let him leave, tried at the door, pushed her on the couch, held her down. That's unduly highlighting one aspect of the testimony. I believe the third sentence is prejudicial, where I again had mentioned get a hold of the prison shank, put it in her face. I don't believe that actually tracks the testimony. Then making her believe her subjective, or I think you could craft something about she had a fear of death, but I don't believe it needs to be as specific as making her believe he was going to use it against her. Giving her a reasonable fear. I think ultimately you need to take reasonable out because that's argumentative, and ultimately in the self-defense that they would get to decide that. I think the statement of that she was going to die like the other countless souls needs to be taken out. I think then the discussion of how the progression is overly detailed. That able to move onto the floor, he fell with her and grabbed the shank from him. That Mr. Dickerson kept grabbing her face, held onto her shirt while she managed to get the shank. Again, I think it should be taken out, that it's a shank, out of her hand, and in a panic, stabbed him blindly in self-defense. So that encompasses the murder aspect. She contends that she's guilty of the arson when she, in a panic, burned Mr. Dickerson's body at the direction of Miss Varela. I don't believe it should say in a panic. I don't think that's supported by the testimony in this. Obviously, the court can look at the time frame of that. She also contends she's guilty of tampering with a deceased body. I don't have an objection to that sentence. I do object to the next statement that she takes responsibility for the actions she did after acting in panic self-defense. And then finally, I don't have an objection that she contends as to the burglary. She didn't take the cell phone, nor did she take the engagement ring. However, I think the previous paragraph of being guilty of the arson needs to encompass the burglary as to arson, because that was established through her testimony. And so as to this, I think those should be included.
All right. Mr. Hio, any response to that?
We can change prison shank to metal file. I think that's fine. I do have concerns. I mean, I do think, as opposed to other theories of defense, when we're talking about a case with self-defense, there needs to be a little bit more information for that, especially because this is a defense that has to be given once the defense is proven by a scintilla of the evidence. I'm happy to work with the court to kind of take down or kind of cut down this first paragraph, but I do believe that there's some necessary, reason to kind of walk through what the actual self-defense is. So looking at People v. Nunez and People v. Dillon, I do think that, of course, we need to have some kind of information here. So that would kind of be where I would start with the first paragraph.
All right. And then as to the second paragraph?
I think that for the last sentence, I do believe that is necessary in order to kind of show where the self-defense starts and ends. I do think it was very clear throughout Ms. Rodriguez's testimony, what she is admitting to, especially in regard to the charged conduct, which also then leads into the third paragraph, where she's contesting the burglary as opposed to the arson and the tampering. I think if the court wants we can burn Mr. Dickerson's body. I think we could take out the at the direction of Ms. Varela. Again, I'm not conceding any of this, but just for purposes of finding a theory of defense that the court's fine with.
So as to the third, I'm going to kind of start from the bottom. As to the third paragraph, it sounds like the state has no objection, so I will leave the third paragraph as it reads. I do share some of the concerns the state indicated regarding the second paragraph. What the court's going to do as to the first sentence, I'm going to remove the clause in a panic and otherwise leave that first sentence unchanged. I'm also going to delete the second sentence regarding taking responsibility and panicked self-defense.
So just to be clear, the third sentence in that paragraph?
I'm sorry, I think it's the second sentence. So with that deletion, oh, I'm sorry, you're right, it is the third. It is the third. I think my copy might be missing that. I'm sorry, you were correct, Ms. Trujillo, deleting the third sentence, and I left the second sentence unchanged. Then with respect to the first paragraph, Ms. Trujillo, I would kind of agree it might be a little overly long and overly detailed, and some of that detail, and it seems like it sort of tracks towards being argumentative. I can attempt to change it, but I would prefer to give you an opportunity to give me another proposal before I do.
Yes.
So if you want to provide some proposed language there regarding the factual scenario, I'm happy to consider that. I would be expecting that any uses of the word shank or prison shank be changed to a metal file.
I think metal file will agree to that. If I could just have a moment to look at this paragraph. Would the court like me to email it or just read it out loud?
If you could email it, that would be very helpful. Mr. Hio, if you could email it to me in this state.
Yes. And it'll just be in the reworded second paragraph.
Okay. All right. Mr. Praley and Mr. McCormick, I've received that. Once you have a chance to receive that and look at that, if you could let me know the state's position as to that second proposal.
That's what it is. That's awesome. Yeah, thank you. There's also this came up. Notice that. These come from Lake Madison. I can put it in there. I just brought these case.
Judge, I think at this time we would still object to the language contained in there. Again, the theory of defense instruction should be general and brief, explaining the evidence and its legal fact. Again, I think it's argumentative based upon the testimony that's come out, and I think that it is not necessarily general in terms of the concept of the theory of defense. And I would, in that particular case, People versus Bruno, 342, P3D 587.
All right. Thank you, Mr. McCormick. Mrs. Trio, any further reply regarding the second proposal?
No, I don't think that there's anything to say that, or I'm not aware of any specific case law that says it has to be brief. So I think no matter how unreasonable or improbable the prosecution believes that the defense's theory is, there's still obviously the need to include, and this is coming from People v. Dillon and People v. Nunez.
All right. The court is going to make some modifications to that. Just a second here. All right, thank you. The court's considered both the defendant's first proposal and the second proposal. The court does have some concerns but that both proposals are argumentative and that both proposals are unnecessarily lengthy. So I have made some modifications in an effort to both highlight Ms. Rodriguez's defense as to the pertinent charges in this while eliminating some of the court's concerns. So in response, the court has modified the first paragraph as follows. The defense contends that Ms. Rodriguez is not guilty of murder in the first degree because she acted in self-defense. Ms. Rodriguez contends that Mr. Dickerson's actions during this incident caused her to be in fear for her safety, and that in response, she used the metal file against Mr. Dickerson in self-defense. And again, the court's already noted on record the court's changes to the second paragraph. So noting the defendant's proposal and continued objection, I will submit that theory of the case instruction to the jury. The next instruction in order begins with every person charged with a crime is presumed innocent. Mr. Hio, I think yours is identical unless I missed something. Is that correct?
It is.
Okay.
I did change defendant and Miss Rodriguez a few times. I'll just double check on the prosecutions.
Oh, did you? Okay. Is that the only change?
On this, it should have been the only change. Oh, and I did. It's the second paragraph. The presumption of innocence remains with Miss Rodriguez.
Give me just a second here. And I'm sorry, Mr. Hio, are you just referring to the change in the name when you said the presumption of innocence remains?
Yes.
Okay.
I'm just changing defendant, and then it should be in the last two paragraphs as well. It'll be the last clause of each.
All right. It looks like the remainder of the language is the same, so I will grant the request to use Ms. Rodriguez's name instead of the defendant in those places where it has been changed. So give me just a second to make that change. Otherwise, it appears the content apart from that is identical, so I will approve that for the jury. The next instruction I have is regarding you should not allow bias or any kind of prejudice instruction. Mr. Hio, it looks like yours is identical. Is that right?
Yes.
I will approve that for the jury. The next instruction is the direct and circumstantial evidence instruction. Mr. Hio, am I correct that the only difference is the deletion of that example language? Is that correct?
Yep.
All right. And from the state, do you have any objection to deleting that language?
I do in this case, Your Honor, and I think the reason why is, well, I would hope it's obvious. There is a vast amount of information that was contained that deals with direct evidence for circumstantial evidence, specifically in the beginning of the investigation, as to what Detective Burroughs was able to determine in terms of the people being there and not knowing. And then specifically there was the question as to that there was a hole in the case because he didn't know all of those things. He, on cross-examination, testified that he still did know, I mean, generally what happened, just not the specifics of who did what. And that goes directly to the direct and circumstantial in conjunction with Dr. Burson's testimony as to the nature of the wounds, the locations of the wounds, the impact. And so in this particular case, I think the snow example is very helpful because the length of the investigation and how it changes highlights that direct and circumstantial at the time of the arrest on November 11th, that all of that was treated a certain way by the detectives, and it's consistent with the specific Colgi instruction where the Colorado Supreme Court Jury Instruction Committee in D01 gives that particular example to highlight and demonstrate to citizens of Colorado what these concepts mean, and therefore I'm asking the court to include it in this specific trial.
All right, thank you. Any further response, Mr. Hio, on that issue?
Yes, I guess actually don't find that to be as obvious here. I don't believe that we really need this type of clarification. I think most of the purpose of the holes would be for the lack of investigation. We had Ms. Varela and Ms. Rodriguez both testify that they were at the home, and they both testified to what they saw in the home. So I think this is more of this was direct evidence is defined as firsthand observation of the fact in question. You had two witnesses testifying to that, so I don't believe that these are necessary.
All right, thank you. Looking at Colgi, this is sort of an optional example. Given the state has articulated a reason behind their request, and I don't find that there's necessarily prejudice or danger of confusion with the jury regarding this issue, I will include that optional language and otherwise approve that instruction for the jury. The next instruction I have is the credibility instruction. Mr. Hio, am I correct? Is yours identical?
Yes.
Okay. I will approve that instruction for the jury. The next instruction that I have is the expert witness instruction. Mr. Hio, am I correct? Is yours identical?
Yes.
Okay. I will approve that instruction. The next instruction is the number of witnesses instruction. Mr. Hio, I believe yours is identical. Is that correct?
Yes.
All right.
So is the next one.
Okay. I'll approve that instruction.
Oh, I apologize. It's not identical. The next one is not.
Okay. The next instruction I have is the right not to testify instruction. Mr. Hio, do you agree that it's appropriate to delete that at this time?
Yes.
And Mr. Pralia, do you agree?
I do.
All right. I will delete the right not to testify instruction. The next instruction is the limited purpose instruction. It looks like the defendant's requested instruction is a little more detailed. Ms. Trujillo, any record that you want to make on your proposal regarding the limited purpose instruction?
Yes, especially for the last paragraph of the Peoples, you are instructed that you cannot consider that evidence except for the limited purpose of motive and the mental states of intent and after deliberation. I don't believe that was the court's ruling. The limiting instruction had been read numerous times to the jury that it was only for the reasons for not reporting the crimes to the police, so I believe that's a misstatement. I think that here the proposed second paragraph, well, first, I guess the first paragraph, I do believe that some of this testimony had come in regard to Ms. Varela and Ms. Rodriguez, so I would be asking that Ms. Rodriguez be named after Ms. Varela in the second sentence of the first paragraph. And then to clarify, because I do think that the People's two paragraphs are inconsistent with each other. We would be asking, especially when we're talking about the credibility purposes, to keep the defense's proposed second paragraph, as it again says that this is only for that limited purpose, and then to instruct them that this evidence is cannot allow them to infer or determine that Ms. Rodriguez has a bad character. This is what 404B prohibits. Even if that evidence does come in under 404B, right, it's for a different purpose, and here for the failure to report. So we would be asked that the court adopt the defense's changes.
And from the state, any record argument regarding that instruction?
Well, I think as to the first part on the People's, I do agree that you included the Stacy Rodriguez for the limited purpose of the failure to report the crimes prosecuted in this matter only. I do agree that on the Peoples that it needs to be changed for the limited purpose of failure to report. I don't think the rest of the defense instruction is valid. So again, I think you should stop it that the court allowed this evidence for this limited purpose. I don't believe that if you do not find beyond a reasonable doubt that the evidence goes to that limited purpose, you must disregard it totally, or any of the sentences that follow. That's argumentative. Don't think it tracks Colgy. And so, again, I think you can add Ms. Rodriguez in the top paragraph for the failure to report. I do think that's accurate. I think the next sentence is for the for that limited purpose, and you can use the defense first sentence because I agree it wasn't allowed for intent and deliberation in that limited purpose. However, everything else is argument.
All right, thank you. I am going to modify both instructions to track more closely Colgy E07.2 regarding limited purpose instructions to be given at the close of the case. So modifying that slightly, I am changing it to read as follows. The court admitted certain evidence for a limited purpose, specifically the testimony regarding prior abuse between Ms. Varela and Ms. Rodriguez was presented for the limited purpose of, a failure to report the crimes prosecuted in this matter only. You are again instructed that you cannot consider that evidence except for the limited purpose I told you about when it was admitted. So with that change, the court will approve that instruction. The next the next instruction is the separate offense instruction. Mr. Hio, am I correct? Is yours identical?
Yes, besides changing the defendant.
Okay. Okay, I do see that. I will go ahead and make those changes regarding the defendant's name. Otherwise, it appears to me to be the remainder of the content of that instruction is identical. The court will otherwise approve that instruction. All right, the next instruction is a definitional instruction. Ms. Trujillo, it looks like, unless I'm missing something, I believe the only change is the inclusion of the definition of self-induced intoxication. Am I correct? Everything else is identical?
Yes, that's correct.
All right. Mr. Fraley, Mr. McCormick, regarding the addition of that self-induced, or I'm sorry, give me just a second. I'm sorry, actually, I had that backward. So, Mr. Hio, it looks like your only change is you've deleted the self-induced intoxication definition. Is that right?
Yes, I just took that out.
Okay, I'm sorry, I misunderstood. And any record that you want to make regarding that deletion?
The defense isn't running voluntary intoxication. This would only be in regard to Ms. Rodriguez as stated by the prosecution's definition, so I don't believe it's necessary here. I think intoxication is fine given kind of the testimony of the parties being drunk on the date of offense, but otherwise I don't believe self-induced intoxication is relevant.
Okay, so you're not putting the issue of voluntary intoxication before the jury?
No.
Okay. Mr. Fraley and Mr. McCormick, with that, regarding its deletion, do you have a position on that issue?
Yeah, I mean, I think it's relevant for the jury to ultimately consider because intoxication means a disturbance of mental or physical capacities resulting from the introduction. And specifically, it applies in this case, based on the testimony of the defendant, that she was falling into the category of self-induced intoxication by drinking, and that the defendant knows or ought to know to have the tendency to cause intoxication, and then that should be that she instead of he, knowingly introduced or allowed to be introduced into, and then it should be her body. I think that's valid here, especially when we're going to dovetail this into self-defense. I think the court needs to take a look at the self-defense instructions and specifically the case law that surrounds the reasonable sober person standard. And so to detail not only intoxication, but self-induced intoxication, specifically that knows or ought to know to have the tendency, and she's introducing it into her own body, then you can't go back and argue of, I didn't know that this would impact me the way that it did, and it wasn't like somebody was forcing her to do that. So it's all connected in those realms, and will ultimately be the jury's determination to look if the defendant's self-induced intoxication plays a role in how she apprises Mr. Dickerson's actions on the night in question, and if it was reasonable, necessary, all those types of things from a reasonable sober person standpoint.
Okay. All right. Given the circumstances in this case, and we'll talk about the self-defense instruction when we get there, I'm not necessarily certain that the statutory definition of self-induced intoxication is necessary or helpful to the jury under the circumstances of this case. The definition of intoxication I will leave in, and I think given the facts of this case, I'm not sure that that's going to be a particularly reasonably contested issue based on the court's view of the evidence, so I will make that deletion. The next instruction that I have is the mens rea instruction. Ms. Trujillo, it looks like your only change, unless I missed something, is the addition of the definition of recklessly?
That's correct.
All right. And just to be clear, and I know we're going to get to the lesser includeds in a moment, but it's from the defense perspective, it's not necessary to include the criminal negligence definition?
No.
Okay. And Mr. Praley, I know we'll discuss lessers in a second, but assuming that those lessers are submitted, do you agree that including the recklessly definition, that definition is accurate?
I believe that mental state in there would be accurate.
Okay, all right. All right. The next instruction I have is the elements of murder in the first degree. Mr. Trujillo, I believe yours is identical unless I'm missing something. Is that correct?
That's correct.
Okay. Court will approve that for the jury. The next instruction I have in the state's packet is the self-induced intoxication instruction. And Mr. Trujillo, it's my understanding you're not asking that be given to the jury. Is that correct?
That's correct.
Okay. All right. I'm going to delete that instruction.
And Your Honor, I still think that's relevant, that they're combining intoxication with self-defense, that she put this booze into her body, and I mean, whether or not there's a jury instruction on it, it's supported by the testimony.
Well, and so I guess we'll talk about the self-defense when we get there, but I guess it seems to me it's the defendant's right to present mitigating incomplete defenses to the jury. I don't necessarily dispute with you that when we get that far that will be a topic that we need to address, but I guess I'm just sort of in a limited fashion just addressing whether or not that incomplete defense is getting submitted. It sounds like the defense is not requesting it be submitted, and I think there's some case law to indicate that and I agree with you that self-defense, the issues relating to self-defense and the issues relating to voluntary intoxication are separate issues, maybe is the best way to put that. I guess if you're requesting that incomplete mitigating defense be submitted, I guess it's certainly not going to hurt the defendant, but I'm not sure that it's necessarily pertinent to the issue that you just raised regarding the considerations surrounding self-defense. So if you have some other record, I'm happy to consider it, I guess. It just seems to me that I'm not sure I understand the purpose behind including that.
Well, I guess the purpose in including it from my perspective is if the defense gets up and argues that Ms. Rodriguez was intoxicated on the night in question and that prevented her in any way, shape, or form from perceiving Mr. Dickerson's actions in the appropriate way, that is directly correlated to the fact that she is under the influence of alcohol that she put in her own body.
So I don't disagree with you there, and I'm sure that we'll have that discussion once we get to the self-defense instruction. I'm only really looking at a limited purpose for a limited presenting an incomplete mitigating defense to the jury. Do you know what I mean? Like I think the two are separate things. They're obviously come out of the same evidence, but and I guess if you want me to submit that mitigating defense to the jury, like I said, I can't see any prejudice to the defense for doing that, but I think they're not the same issue.
Okay.
Does that make sense? I guess I'm not understanding.
Your Honor, I don't know that it does make sense to me, but
okay.
Ultimately the court's going to provide the instructions. I think I've made my record.
Okay.
If that becomes an issue in closing, how do we remedy it then?
Well, and maybe this is a more productive conversation to wait till we talk about the self-defense instruction and talk about those issues. And then after we talk about that, we can revisit whether or not it's appropriate to include that voluntary intoxication language.
That makes sense, and I agree with that.
Okay. All right. The next, then we'll kind of defer some of that discussion until a moment. The next instruction that I have is a 2-page instruction regarding lesser included offenses. And then, Ms. Trujillo, I think the only change that I see, unless I'm mistaken, is just also adding manslaughter. Is that correct?
Yes, adding manslaughter, and then I did add another sentence after manslaughter, so it would read, the offense of murder in the first degree after deliberation as charged, and the information in this case necessarily includes a lesser offense of murder in the second degree and manslaughter. And then here I include, based on People v. Richardson, you are not required to deliberate on the charged offense before considering or deliberating on the lesser included offenses.
Okay, I do see that additional sentence. Mr. Pereira, can you give me your position on the defendant's changes?
I object. I don't think they're colgy.
And I'm sorry, Mr. Pereira, you object and what?
Excuse me, Judge. I don't believe it's based on colgy unless they want to provide which instruction that language tracks.
And so just so I'm clear, do you object as to the inclusion of manslaughter?
I don't really think I can.
Okay. And so you're only...
Objecting to that last sentence that they included from case law, you're not required to deliberate. That's the portion that we're objecting to.
Okay, all right. All right. Mr. Pereira, understanding that's the only portion that you object to, any further argument on that?
No, Judge.
All right. Any further argument from the defense?
Just in case the prosecution needs it, it's People v. Richardson, 184 Pacific 3rd, 755, Colorado, 2008. And it very clearly says that Colorado is a soft transition state. And I think the jury needs to have that. I don't think that it's common knowledge.
Okay. Based on the court's review, I do find that both the inclusion of manslaughter is appropriate, as well as I don't see any prejudice to either side from including the sentence requested by the defense. So I am going to give the defendant's instruction. Give me just a moment to make that change. All right, the next instruction that I have is the defense of person instruction. It looks like there's a few changes made by the defense. First off, it looks like the defense included manslaughter regarding the crimes that this applies to, and it also looks like the defendant has deleted the provocation instruction as well as the initial initial aggressor part of that instruction. It looks like the state's instruction also includes a sentence regarding a reasonable person standard as it relates to a reasonable sober person. Ms. Trujillo, any argument in favor of your instruction?
Yes. Just kind of, I understand where the prosecution had, I'm assuming from Colgy, but I think it gets a little confusing because, especially when we spent so much time during voir dire on the duty to not retreat. So, the prosecution had started it, I think, with saying Ms. Rodriguez was legally authorized to use physical force upon another person without first retreating if. So I believe when you read that, common sense would lend you to think that the person first either needs to determine if they can retreat and then go into the factors. So that's my basis for taking that part out or changing that with just ending it a little bit shorter. I do believe when we're considering just self-defense, looking at Monroe and Jones, it isn't necessarily whether or not, especially with the facts of this case, that we need the non-aggressor or the initial aggressor. And I do believe that including any kind of language of no duty to retreat or duty to retreat when we're looking at People v. Garcia, as well as Idrogo, IDROGO v. People, 818 Pacific 2nd, 752, Colorado, 1991. Kind of confuses it for the jury. So in regards to the fact that there should not be any type of phrasing of no duty to retreat, we would be asking that the court adopt it with just the two factors underneath.
All right. And then with regard to the manslaughter portion of that, and I don't remember the case off the top of my head, but I believe there's some case law indicating that the affirmative defense of self-defense does not apply to manslaughter. Do you have a position on that issue?
It's element negating for the recklessly. I'm looking at specifically if we're and I think maybe we can just clarify with the recklessly, it would negate that mens rea. I'm looking at comment 7 under H11.
And I think that usually indicates that there's a separate instruction to be given in that instance.
And then I think that would be appropriate.
Okay, all right. And then any other record regarding the other portions of the state's instruction?
No, not in addition to what we said before as well.
Okay. All right, so let me go over this. Give me just a second. Oh, so to go over this in order, I am going to remove the reference to manslaughter, although I will include a separate instruction regarding that issue that I believe is contained in H13, but you'll need to give me a moment to check on that to make sure I have that cited correctly.
That's correct.
Is that correct, Mr. Braley?
It is.
With respect to the defendant's request to remove the without first retreating language, I am going to deny that request and include that phrase as indicated in Colgy. I disagree with the defense that issues of propagation and initial aggressor are not present in this case, so I am going to include on the request of the state the paragraphs 3 and 4. I believe otherwise the language does track Colgy. And then, Ms. Trujillo, you did not address the sentence regarding the reasonable sober person. Do you have anything that you want to say about that?
Yes, I think. I mean, I guess this is where I get kind of confused on the prosecution wanting the voluntary intoxication. One, this isn't Colgy. So if we're relying on Colgy for having the retreat language in here, I think the same thing should apply I also think that's that is argument for the prosecution to look at, because if we are talking about imperfect self-defense, looking at Sanchez v. People, it's the fact finder has to weigh all relevant circumstances to determine whether a person asserting the defense of self-defense has acted as a reasonable person would act in similar circumstances. And so self-defense has an objective and subjective component. And so based on that, we would be objecting to including that, but the prosecution obviously can argue that in closing.
All right, thank you. Based on the court's review of People v. Martinez, cited at 22 COA 111, that case discusses the reasonable person standards in the context of a reasonable sober person, and I think directly holds that the reasonable person standards requires a defendant to appraise the situation as would a reasonable sober person. So I disagree that that's merely an element left to argument. I believe that that is an accurate statement of the law in Colorado, so I am going to include that sentence. Mr. Pralia, does that change your position regarding the voluntary intoxication, or do we need to discuss the other self-defense instructions first?
Let's keep going, and then we'll confer.
Okay. All right. Give me just a second to get back where I was. The next instruction is the deadly physical force instruction. Again, I'm going to maintain my same ruling regarding including manslaughter in there. Mr. Trujillo, it looks like otherwise your instruction is identical with the exception of you've deleted 4 and 5 against the provocation and the initial instruction portions of that instruction, and the reasonable person, sober person portion of that, which I've already referenced. Ms. Trujillo, is your, given the similarity of those issues, is your argument essentially the same for the deadly physical force instruction, or do you have anything specific to that instruction that is additional?
It is the same, and just for the record, we would be asking to delete without first retreating, but understanding the court's previous ruling.
All right. Then I'm going to keep that instruction consistent with the court's previous discussion on the issue. I will remove manslaughter from the list of crimes that this is applicable to. I will leave in the provocation and initial aggressor language. I will also include the reasonable sober person language, and otherwise approve that for the jury. And then, Ms. Trujillo, what I'm going to do, this is the point that I am going to include H13 of Colgy, which is the evidence, the instruction that you had referenced regarding the element negating part of that. Give me just a second. Do you have H13 accessible to you?
I do. I'm looking at it.
Okay.
To be clear, H13 deals with non-deadly physical force for a mens rea of recklessness. That would include manslaughter. And H14 deals with deadly physical force for recklessness. So based on, I guess, that aspect, you would need to include both H13 and 14 as separate instructions. And then I'm asking for the same elementals as well as the reasonable sober person language at the bottom.
Okay. All right. Mr. Heo, and that is correct. I would include both H13 and H14. Noting the defendant's objection, I would include the provocation and initial aggressor language to keep things consistent. And give me just a moment here.
While the court's doing that, I agree that both H13 and 14 should be included. We would just be renewing our objection in regard to the elementals and the duty to retreat.
Okay. Give me just a second here. All right, what I'm going to do, I am going to include H13 and H14, and I am going to include them in a way that is consistent with the court's inclusion of the affirmative defense instructions.
Yes, please.
I will include both of those instructions with the provocation and initial aggressor language. Given H13 and H14, also include a reasonably standard included within those definitions. I'm also going to include the reasonable sober person language, and I will note in both of those instructions that those instructions apply to the lesser included offense of manslaughter.
Thank you. Your Honor, before we move on, could I just cite a few more cases on this topic?
Go ahead.
Okay, thank you. Looking at Galvin v. People, 476, Pacific 3rd, 746, Colorado, 2020, it goes into the three kind of prongs of when a defendant forfeits self-defense, the third being the defendant intended his provocation to goad the other person into attacking him in order to provide a pretext to injure or kill that person. The defense's position is that does not exist here. Also, People v. Silva, 987, Pacific 2nd, 909, Colorado Appeal, 1999, includes the assertion that words alone are not enough. And the court there had strongly suggested that words alone were not enough for that kind of type of provocation we're talking about. Galvan had not necessarily answered that, but just for the further record, we just wanted to include those cases.
All right, thank you. The next instruction I have is the elements of first-degree arson. Mr. Heo, I think yours is identical, is that correct?
Yes.
Court will approve that instruction.
And Your Honor, for first-degree arson, I had conferred with defense. We need to take out element 8 as to self-defense, the affirmative defense. They're not saying any kind of affirmative offense or defense applies to this.
And Mr. Heo, do you agree that the deletion of element 8 is appropriate?
I do.
Okay, all right, I will delete element 8 of that instruction. The next instruction is the interrogatory regarding an occupied structure. Mr. Heo, I believe your instruction is identical, is that correct?
It is.
Okay. I will approve that instruction. The next instruction that I have are the elements with tampering with a deceased human body. Mr. Heo, I believe yours are identical, is that correct?
That's correct, and then we'll just have to delete elemental 9.
Okay, and Mr. Praley, do you agree with that deletion?
Yes, and then so we just need a period at the end of 8 and delete 9.
Okay. All right, I've made that change and will otherwise approve that instruction. All right, the next instruction is the second-degree burglary arson instruction. Mr. Heo, I believe yours is identical. Is that correct?
Yes, and then we'll just delete elemental 7.
7, okay. And Mr. Praley, do you agree?
Yes, and to be clear, I wasn't completely sure how to approach this on number 6 because it references the crime of arson as defined in instruction blank. and yet I included it right after it on the next page. In this case, they actually do have arson, so I didn't know how the court wished to do that. Because a lot of times when you're dealing with the other crime, it's not a charged crime. And so I just wanted to point that out to everybody, that I struggled with that on both fronts, whether you just reference the actual charged arson instruction or if you include it on the next one. As long as we're in agreement, I really don't have a massive preference, but wanted to put that on everyone's radar.
Mr. Hio, it looks like both of yours, that one and the one following, are identical. Unless you have strong feelings about it, I would just leave them as submitted by both parties.
I think that's fine. I think it's also clear. I don't have an issue with that.
All right. Then I'll just leave it as it is, and I'll number them appropriately.
We're just taking 7 out, right? Element 7.
The affirmative defense one. All right. The next instruction that I have is the interrogatory regarding dwelling. Mr. Hio, I think yours is identical. Is that correct?
It is.
Okay, then I will approve that instruction. The next instruction I have regards burglary theft. Ms. Trujillo, I think yours is identical. If it is, are we just deleting that element 7?
Yes.
Okay. And Mr. Praley, do you agree with that deletion?
I do.
Okay.
There, I did, actually, I apologize.
Oh, I'm sorry. Is there a change?
Sorry, no, I just wanted to make sure that Ms. Rodriguez was stated as the defendant in those, and she was, so there's no change there either.
All right. And then sort of the same conversation regarding the following elements of theft. Mr. Hio, I think yours is identical, so unless you have strong feeling about that, I just leave it as submitted.
I agree, and there's not a separate charge theft, so that's fine.
All right, then the court will approve that instruction. The next instruction is the interrogatory regarding dwelling as to that count, which I think is identical on both parties and identical to the court's previously approved instruction. Mr. Hio, do you agree?
Yes.
All right, then we'll approve that instruction. The next instruction regards discussing the case only in the jury room. Mr. Hio, I think yours is identical. Is that correct?
Yes.
Court will approve that instruction. The next instruction is the questions during deliberation. Mr. Hio, I think yours is identical. Is that correct?
Yes.
Court will approve that instruction. The next instruction is the concluding instruction. Mr. Hio, I think yours is identical. Is that right?
It is.
Okay. We'll approve that instruction.
I don't know if the court wants to take that language off of the defer until final conference.
Oh, I did. I took that off.
Okay, thank you.
And then, Mr. Hio, regarding the verdict forms, is the only change that we need to make to include manslaughter?
Yes.
Okay, and otherwise, are they identical?
Yes.
Okay. All right, so I've changed the jury verdict form from count 1 in the first portion. It now reads not guilty of murder in the first degree and not guilty of murder in the second degree and not guilty of manslaughter. And then I've changed the second portion to include manslaughter as an option. Otherwise, I believe the remainder of the jury verdict forms are identical. All right, Ms. Trujillo, apart from changes or objections or other records made during this conversation, is there anything else that the defense needs to address regarding the jury instructions?
No.
And Mr. Pralia, anything else from the state?
No other verdict forms are changed, is what I'm understanding?
No, the only thing that I changed is including manslaughter on the first one.
I don't believe so, Your Honor.
Okay. All right, then I will consider those finalized. What I'm going to do, I still need to go back in and add the language regarding H13 and H14. I got a couple cases I need to address here, but I will add that language, and then I will email a finalized copy to the parties before I leave today, so the parties can review those before we begin to ensure that there's no typographical errors or anything else that needs to be changed that didn't reflect our jury instruction conference. If you could notify my staff by 9 a.m. Tomorrow regarding any typographical errors. If they don't hear from you both, they'll start the process of printing and copying those instructions. From the defense, is there anything else that we need to address before we recess in this matter?
I don't believe so for today.
Anything else from the state?
No, Your Honor.
Okay, then we'll be in recess in this matter until noon tomorrow.
Noon exactly, Judge?
I'm sorry?
12 exactly?
If we could, I don't, like I said, sometimes those sentencing hearings kind of get away from me, so that's my best guess I can give you, Ms.
No,
Deborah.
it's okay. I just didn't know if you were going to take a lunch at all, so.
No, probably not.
Cannot forget. Because
Noon tomorrow.
it's contract.
Is it?
Well, that's why.
I was reading the contract.
That's
Yeah.
what's good that we have here.
Thank you.
And ladies and gentlemen in the gallery, if you are here for a 3 or 3:30 case due to our trial, those were delayed. We will begin all of those cases at 4 p.m.